from supplementary list for final disclosure item 2, 2nd April 346 of 2017.
We will argue the case.
Sorry?
We will argue the case.
Okay.
The substantial question of law. I read once again, with your notice, please. Whether
SPT
the
Act.
Milord,
आप बहस करते रहिए, हम सुन रहे हैं, कुछ भी कर रहे हैं. I am absolutely audible,
Milord,
and you are also audible, and I am absolutely attentive to whatever you
Milord,
say.
Milord.
साथ साथ हम कभी कुछ एक्ट भी देखेंगे, कुछ पलट
जी हाँ,
भी
जी हाँ, जी हाँ.
देखेंगे. But I am absolutely receptive to whatever you are saying.
Milord,
Wait
Milord.
नहीं करने का, unless I ask you to.
We all know, Milord. My words.
Yes, please.
Whether the order of eviction of defendants are respondents in our title suit. So whether their eviction passed by SDO and Deputy Commissioner in Rayati eviction case number 9 of 85-86 and then revenue miss appeal number 19 of 87-88 by order dated 22/4/87 and 30/5/89, my lord, respectively, can be set aside. These two orders were passed by SDO and DC Minot by the revenue courts, exercising their powers under section 42 of the SP Tenancy Act, Minot. Now, whether these orders passed by the SDO and the DC, exercising powers under section 42 of the SP Tenancy Act, can be set aside by the civil court in title suit number 24 of 89 in utter disregard and flagrant violation of section 63 of the said act or not. So this section 63, we will read that. And then the second question also, whether the appellate court below, while deciding the title appeal number 13, 15 of 2014, has not considered section 63 of the SP Tenancy Supplementary Provisions Act in its right perspective. So we are in second appeal. About the first appellate court, not the second question relates that the first appellate court did not consider or decide section 6 on the basis of section 63. Now these, my humble submission for your lordship's consideration is that, and recently also, my lord, this honorable court has passed a judgment, my lord. We have come across, though I have not brought that, but it is in my mobile, my lord, and it's not being downloaded. हम लोग लाके हुजूर एक वो दे देंगे सेक्शन 63 पर.
सर ऐसे मत करिए प्लीज. लाके दे देंगे, कब दे देंगे? हम तो अभी ऑर्डर लिखाएंगे. आप बताइए कौन सा केस का नंबर बताइए.
हुजूर वो डाउनलोड नहीं.
केस का नंबर बताइए. डाउनलोड नहीं हो रहा, नंबर बताइए, हम डाउनलोड करते हैं यहाँ से. नंबर आई एम लुकिंग फॉर द नंबर.
डाउनलोड होने पर ही नंबर आएगा ना.
तो आपने जो क्लिक किया होगा उसमें कुछ तो क्लिक किया होगा.
One learned lawyer has said to me, who had argued before this court in that case.
सर ऐसा ये anticipation we just do not know. आप इस जो चीज आपके पास नहीं है उसको आप मत ले सकते. कौन एडवोकेट ने आपको भेजा है? नाम बताइए एडवोकेट का.
श्री राहुल गुप्ता.
मिस्टर राहुल गुप्ता, बुलाइए. अभी उनका केस ही टेकअप होने वाला. बुलाइएगा मिस्टर राहुल. अभी उनका मैटर है, अभी टेकअप होगा उनका.
बुलवाते हैं. WhatsApp में आया है। ऐसे देखो। Now, my lord, I proceed with your lordship's leave.
Mr. Rahul Gupta? Mr. Sharma is saying that you have sent one judgment to Mr. Sharma regarding section 63 of the SPT Act.
Yes.
Kindly give me the case number. He could not download that.
It was second appeal 190 of 2019.
190 of 2019.
Yes.
Decided on?
Decided on
इसका प्रिंट निकालिए.
date, 19th of December 2024.
19/12/24. Any SLP filed?
And the party's name is Mithu Mia versus Mohammad Yaqub.
Any appeal filed? The Supreme Court? Any appeal
That,
filed?
that,
No idea.
but they are going.
Yeah.
I was the appellant. Appeal was allowed in my favor. The other side probably there.
We'll take out the judgment. Suit is not maintainable.
Suit, yes, because if
Even in
a
cases of
proceeding
fraud,
was
etc.
yes, because a proceeding, if there was an order in a proceeding under section, then in the SPT Act, and there was an order of eviction under the Act, then suit is not maintainable because it would be appeal is maintainable against that. So that attains finality, and then to avoid that, a suit is not maintainable. That was what was it. I'm not aware of the
In
fact
cases
of this.
of no, I just want to know. Even in cases of fraud, etc., it is not maintainable.
No, in
They will
that
attribute
case,
the fraud also.
in that case, it was not the case.
Okay, we'll see that. Thank you. You have a case today. Spare some time. I'll need you in another case also.
Yes.
For with regard to procedure,
I'll
because you have lot many matters in civil court, so that procedure I need to. There is some cloud regarding the procedure. Tell you.
No. Lord, so my first humble submission is, Lord, that the filing of, when lost before the review court in orders passed in exercise of the powers under section 42 of the SPT Act, Lord, the SDO and the DC, they both had powers, Lord, under the, so the orders passed by SDO and DC can't be said that they were not competent court.
That's right.
And once they have passed the, as a revenue court exercising powers under the SPT Act, Lord, suit will not lie as against those orders passed by competent authorities, SDO and DC. Now this is my first submission for your Lordship's kind consideration. And therefore the suit of title suit number 24 of 89, which was filed, Lord, for setting aside or making the declaration that the orders passed by SDO and
What
the
was the
DC.
plaint about?
Pardon?
Let us see the plaint. Plaint.
Our plaint.
What was the relief?
Of this case.
Yes, of course, of this case.
No. इसमें रिलीफ पहले पढ़ देते हैं
हाँ, relief ही पढ़ी.
at page 8, para 22. Plaintiff pray for the following reliefs. It be hold and declared that the ex parte decree passed in title suit number 24 of 89 is void, illegal, inoperative, without jurisdiction, and against the provisions and other law not binding upon the plaintiff. it further be declared and hold that ex parte judgment and decree passed in title suit number 24 of 89 will not be binding upon the eviction orders passed by the SDO and Deputy
So
Commissioner.
essentially, you filed a suit for setting aside the decree passed in title suit number 24 of 89.
My lords.
And in title suit number 24 of 89, these orders were set aside.
These orders were.
So it is not a case that in this particular proceeding, these orders were set aside.
Pardon me.
That it is not a case that in this particular proceeding,
My lord.
in
In our
title
title-
suit number 3 of 25-26, these orders were set aside. These orders were set aside in the earlier suit, that was title suit number 24 of 89,
As against which I filed this suit.
as against which you filed the suit. Now tell us that the relief, the subsequent relief is connected with the first relief. Correct?
My lords.
Whether the relief which you have prayed for, the first relief, could it be decided by the revenue courts? Could it be decided by the revenue courts? Could the revenue court
Yes.
set aside this particular title decree passed in title suit?
No, revenue court
No.
can't.
So your entire relief is arising out of setting aside of title suit number, the decree passed in title suit number 24 of 89.
My lords.
So the question of law which you have got framed, that whether the courts have the power to set aside the orders passed by the revenue court, that is a consequential relief. That is not the main relief. The main relief was to set aside a decree passed in the title suit. And if the decree passed in the title suit is annulled, then under such circumstances the consequences will follow.
So we did pray, my lord. My lord, the prayer is number one.
Yes.
Relief number one.
Yes. And number two?
Number one, I read once again.
Yes.
It be hold and declared that the ex parte decree passed in title suit number 2489 is void, illegal, inoperative, without jurisdiction,
Okay.
and against the provisions of law. So this is my relief, main relief.
Yes.
Now main relief is thereby making those revenue court's orders, have been made inoperative by the civil court, which the civil court has no power.
Okay.
So therefore, in this suit, we prayed for a declaration that the decree that was passed in title suit number 24 of 89, rendering or setting aside the revenue court's order, be declared as void, illegal, inoperative. And then
Whether this relief could have been granted by the revenue court, that the decree is annulled, can the revenue court declare, once a decree is passed, even if ex parte, can the revenue court declare that it is not binding? You say that the suit was not maintainable in view of section 63. Your entire case is that title suit number 24 of 89 was not maintainable.
because
So if that decree is to be set aside or is to be avoided, can this order, this relief of yours, be taken care of by the revenue courts?
this is not revenue court.
This is not revenue court. Therefore,
I am before the civil court.
that's right. Therefore, the point of law which has been formulated, that whether the order of eviction of defendants passed in this civil court can be set aside.
By the revenue court.
Yes. So,
Whether that can be set aside by the civil court, that is the question.
so the relief that you prayed for,
We were aggrieved, we were aggrieved by a decree of the civil court which held the revenue court's order of eviction as null and void or set aside. So we were aggrieved by that. So we wanted, my lord, in this plaint, that those orders of eviction passed by the SDO and DC should be made operative. Can't be-
After a declaration that the title suit number 24 of 89 is void. Only after a declaration.
Milord,
Where is the decree of title suit number 24 of 89? Exhibit number?
that is the exhibit C and C1. Judgment and decree of the earlier titles.
We have seen it yesterday that you were a party there.
We were parties, pleaded as parties, Milord.
Yes.
But the order sheet, entire order sheet, we have annexed, Milord, and we exhibit 1, which will show, and I will show to this
That
court.
is a separate thing.
Milord, I will show to this court the summons were never issued.
That's right. If
The
the
order
summons
sheet
were
will
never
show-
issued, if in a case where an ex parte decree is passed and the summons are never issued or there is any such violation which warranted that the ex parte decree was required to be set aside, then under such circumstances you have a remedy under the Act,
Milord, my
which you have
humble-
not availed.
Milord, humble submission is that it was not an ex parte order. Because Supreme Court and this court, there are decisions, Milord, in which your lordships have held that once appearance has been made by the defendants and then they left pursuing the case, then the order or decree that is being passed, Milord, by the civil court is not an ex parte order. Can't be said to be ex parte because they appeared. Now here the judgment that your lordship is saying, which was impugned in this plaint, Milord, of ours, the impugned judgment, Milord, shows our appearance. So therefore, it was not an ex parte decree. Though in the plaint we have written ex parte, that is, misconceived, Milord. That word. Your lordship will kindly consider it was not an ex parte order, because the entire order sheet will show appearance. And we say that that was a fraud. And from the order sheet we will show, Milord, exhibit 1, from the order sheet, कि समन हम लोगों को कभी इशू तक नहीं हुआ ऑर्डर में. Milord, in the whole title suit of 24 of 89, I will show to your lordship, Milord, for your lordship's consideration. Summons never issued. और उसके बाद दिखा दिया appearance. So whatever be, Milord, it was not an ex parte decree according to the judgment or decree that was passed. And both the courts, Milord, they did not consider section 63. They said we are not sitting in appeal against the judgment and decree passed earlier by the civil court, and they said that the civil court was competent to pass such a decree, setting aside the revenue court's orders. That was a decree by a competent civil court, and we are not sitting in appeal, and so therefore we will not decide section 63 or whether that decree was illegal and violative of section 63. This is what both the courts said. So it all boils down to for
Where is
consideration
the
by
finding
this.
recorded by the learned trial court?
Trial court. My Milord,
Issue number 6.
Trial court page 10.
Issue number 6. Page number 6.
Milord, this is page number. Trial court, Milord.
Yes.
जी हाँ, ये पढ़ते थे. issue is most primary and whether the decree passed in title suit number 2489 is binding upon the plaintiff. This issue is most primary and main issue of the suit is, so it is taken for first for adjudication. Regarding this case, this issue, the case of plaintiff is that title suit number 2489 brought by defendant has been decided ex parte by using fraud, and this plaintiff and his father never appeared and said suit, but their presence was managed falsely and thereafter by making them absent from the said proceeding of title suit number 2489. These defendants got ex parte judgment and decree behind the back of the plaintiff, and since plaintiff did not know about title suit 2489, he could not take any recourse earlier to annul the said judgment and decree, and when he came to know about the decree, then this plaintiff filed a suit. So decree got by playing fraud is nullity and ab initio void and not binding upon the plaintiff, and that is why the plaintiff has come with prayer to annul the judgment and decree of the title suit 2489. It is also the case of the plaintiff that section 63 of the SPT Act bar the jurisdiction of the civil court. So eviction order passed by SDO and DC in RE case and its appeal cannot be declared void by civil court, and the said judgment and decree of title suit 2489 is against the mandate of law. So the judgment and decree is null and void and not binding upon the plaintiff. The learned counsel for the plaintiff also submitted in this regard that father and uncle of the plaintiff died in the year 1984 and 1986 respectively, but in title suit 2489 they have been made party and their appearance has been shown, which is clear that dead persons have also been shown as appeared in title suit number 2489. Here I just pause, with your lordship's leave. In the plaint para 9, we have specifically stated that Lakhi Mandal, my father, he died in 84 and my uncle died in 86. Now that has not been denied.
Kindly continue reading.
Not denied.
Kindly continue reading.
The learned counsel also pointed out that Exhibit 2 is summon issued in said title suit, but there is no service report of the same. No service report और issue करने का भी order नहीं है. हम entire order sheet रात में पढ़ रहे थे हमारा. I will show issue तक नहीं हुआ समन और तुरंत दूसरे डेट तीसरे डेट में हमको अपीयरेंस सब दिखा दे रहा है और कौन कौन हाजिर हो गए. ऑर्डर शीट वो देखने लायक हमारे. शुड आई
नहीं आप पढ़िए ना. हम आपकी यहाँ जितनी चीज लिखी हुई है हम उसको सच मानते हैं.
वी आर सो ऑब्लाइज्ड माय लॉर्ड. उस शुरू का ही सेकंड पेज ऑर्डर शीट में आया है कि रिक्विजिट फाइल हुआ और इशू करके कहीं नहीं है कि समन इशू और रिसीव हुआ समन उन लोग को सर्व हुआ. नो ऑर्डर शीट. This is something very important which both the courts, Lord, they did not consider this aspect. Summons never issued nor served. कोई ऑर्डर शीट भी.
Who is in possession of the property?
Admittedly हम लोग तो कह रहे हैं कि वो लोग दखल ले लिया. दखल में मतलब वो लोन हम लोग जो एबॉरिजिनल है, हम लोग की जमीन है एंसेस्ट्रल और ये 75 के आसपास.
मेरा एक क्वेश्चन का जवाब दीजिए. Who is in possession of the property? They are in possession of the property.
They are in possession and wrongful possession.
That's
Therefore, they were evicted, my lord, by the revenue courts under section 42. कि जो illegal occupation में आएगा, the DC, the SDO has the power to evict them under section 42, my lord.
That's right. Again, on the other hand,
but there is no service report of the same which shows that never summon was served, and these defendants have dishonestly shown dishonestly shown appearance of the plaintiff and his father in title suit number 2489, and false information was filed by the plaintiff in title suit number 2489, alleging that Lakhi Mahaldar, father of Balram Milord appellant, died on 15/1/94, and to create confidence upon court, such information was arranged in the name of defendants of title suit 2489 and got filed petition regarding information that Lakhi Mahaldar died on 15/1/94, which is fraudulent act of plaintiff of title suit number 24 of 89. Who are the defendants. The learned counsel also submitted that as per section 63 of the SPT Jurisdiction Act, jurisdiction of civil courts has been barred, then judgment or decree declaring eviction order of SDO and DC is null and void is fully against the law, and the said judgment and decree is null and void.
ऐसा कोई finding नहीं है judgment and decree में that it is null and void. The decree is only a permanent injunction. कोई null and void बोल के कुछ finding नहीं है.
Null and void करके कोई finding
हाँ,
नहीं.
this submission is
और
not.
सेक्शन 63 वगैरह कोई डिस्कशन
वो आपने appear होकर कोई objection ही नहीं हुआ तो कोर्ट सूट proceed कर गया और सूट ex parte decide हो गया.
whatever be my lord, but we say that we never appeared and it was all fraud and वो simple एक judgment है. Your lordship is very right. I have already gone through the judgment, my lord. उसमें null and void करके नहीं बोला है, लेकिन ineffective कर दिया उसको. और लेकिन ये कह दिया कि इन लोगों का adverse position पर title हो गया.
नहीं ऐसा भी नहीं हुआ. Permanent adverse possession का कोई finding नहीं है सर. I could not get any.
वो long continuous possession बोल दिया खाली उतना ही.
It's a adverse possession थोड़ी होगी.
हाँ तो और करके वो permanent injunction बोल दिया. ये my lord. On the other hand, the case of the defendants is that defendant of title suit 2489 appeared in response to show cause notice of ad interim injunction and filed a show cause and contested the suit, and also filed petition regarding maintainability of the suit 2489, although that petition was later on dismissed by the court. And when order of injunction was passed in favor of the plaintiff of title suit number 2489, then defendants lost their interest from the proceeding of title suit 2489, absented themselves, and that is why the suit was decided as per provision under Order 8, Rule 10 CPC. The learned counsel also submitted that if plaintiff thinks that title suit 2489 was decided by playing fraud, then it was bounden duty of the plaintiff to prove it, but to prove the said assertion, no step has been taken by the plaintiff. Since plaintiff is well known that defendant of title suit number 2489 appeared and contested the injunction petition, and that is why, due to fear of adverse evidence, plaintiff did not take a step to bring evidence of show cause, affidavit, petition, or to examine the learned counsel Shri D. N. Yadav. So, what may be the tools to prove the fraudulent act, if any, committed by plaintiff of title suit number 2489? Then these tools ought to have been brought by this plaintiff. But plaintiff knows it very well that those documents are correct and true. That is why they have not been brought more documents, and as per Evidence Act, burden of proof as well as onus to prove regarding fraudulent acts, if any, committed by plaintiff of title suit number 2489, lies upon these plaintiffs. The learned counsel also argued that from Exhibit 1 brought by the plaintiff side is the order sheet of title suit 2489, and this order sheet shows that proceeding of title suit number 2489 was continued as procedure laid down in CPC, and it shall be presumed that the court passed judgment or decree, then it will be genuine, and if anyone challenges its genuineness, then he must prove. But in this particular case, plaintiff has not proved any fraudulent act such judgment or decree passed in title suit number 2489 is final and it's binding on the parties, including this plaintiff. The learned counsel for the defendants also submitted that 663 SPT Act is subjective and it depends upon the matter of each case. And in a particular case, the then court has declared the order of SDO and DC in Rayati eviction case and its appeal as void and without jurisdiction, so that declaration passed in title suit 2489 got its finality.
Limitation Act.
And when
Limitation
there is no proof of any fraudulent play, then decree of title suit 2489 cannot be challenged. The contention of defendants is also that since decree in title suit 2489 was passed in the year 1995, then after lapse of more than 11 years, this title suit number 3 of 2006 has been filed, which is hopelessly barred under the provisions of law of limitation. The learned counsel for defendant has cited case laws, AIR 2014 Supreme Court page 1155 submitted that if defendant did not file WS, decree passed ex parte is valid for all purposes. Another case also cited 2011 to JLJR Supreme Court case circular submitted that burden to prove lies on persons who asserts fact, and in particular case to prove the alleged fraudulent play ought to have been proved by the plaintiff. The third case law AIR 2004 Supreme Court page 937 has been filed by the defendants with submission that plaintiff has to prove its own case and he cannot depend upon the weakness of defendants. Lastly, on the basis of above, the learned counsel for the defendant has proved that the decree of title suit 2489 is the result of proper procedure of law and it was contested by the defendants of that case who are plaintiff of this case, and later on they left the same, and hence that was absolutely proper and that was passed under order 8 rule 10 CPC, that judgment and decree remained unchallenged till filing of the suit for 11 years. So the decree of title suit 2489 is fully proper and binding upon the plaintiff. On going through the oral arguments of rival sides and pleadings to the parties, it appears that the main bone of contention of this suit is whether the decree passed in title suit 2489 was based on fraud, misrepresentation led by plaintiff of title suit 2489 by showing fake appearance of defendants. It appears that firstly fraud is to be considered and then other matters may be considered. So firstly this point is being taken to decide this issue. For better understanding, it is hereby clarified that in title suit 2489, plaintiffs were Mani Musammat, Babulal Mandal, Musammat Batia, Gopal Mandal and Pramod Mandal, who are defendants in the title suit number 3 of 2006 and defendant in title suit number 24 of 89 was Kalu Mandal, Lakhi Mahaldar, both sons of Bulaki Mandal, Balram Mandal and Jagdish Mahaldar, out of which Balram Mahaldar is plaintiff in this suit. 3 of 2006. On going through the whole case record, including oral and documentary evidence, it appears that as oral evidence for plaintiff, only evidence of PW1 Balram Mahaldar is here, who is plaintiff of this case. On perusal, it appears from the examination in chief, which is in form of affidavit, there is only mentioning that he did not receive summons.
I have read it. You just tell us, when did he die, Lakhi Mahinder? 1984.
1984 Milord Lakhi Mahaldar
Mahaldar died.
and Kalu Mahaldar 86. This we specifically stated in para 9 of the plaint, which has not been denied, Milord, which I will show, Milord.
Just a moment. So decree was against dead persons.
Against dead persons. And this was not denied, so therefore we need not prove. This is what your lordships have always said, Milord. And it's a settled law. And the and relevant provision of the CPC also says, if not specifically denied, means admitted.
Which paragraph of your plaint?
Milord,
Para number
para 9, Milord Mikali.
and reply.
Milord, I'll just. Para 9, Milord. That the fathers of the plaintiff had died in the year 1984 and 86 respectively. In spite of that, those dead persons were named in the said title suit as defendant number 1 and 2, and later on their names has been deleted as revealed from the certified copy of the plaint.
Which plaint? Certified copy of which plaint?
1 and 2, and later on their names have been deleted. Milord, plaint of 2489.
In that case, it was reported that they died in 1994.
हाँ, they have said.
Yes. So
करके उसको delete करवाया.
delete करना.
That is.
और इसका reply क्या है?
हाँ, इसका reply para 13 हुजूर देखा जाए. Para 13 of WS. लंबा पैराग्राफ पूरा पढ़ देते हैं. That the statements made in para 7, 8, 9 हुजूर अभी हम लोग पढ़ रहे थे, 10, 11, 12 and 13 are admitted to the extent that the plaintiff's late father had filed a proceeding under section 42 of the SPT Act for eviction of the defendants in the court of the SDO Sahibganj, which was registered as RE case number 98586, in which eviction order was illegally passed on by Vice 87. The said order of SDO was without jurisdiction, which fact could not be appreciated by the Deputy Commissioner in appeal filed by the defendant number 1, and the appeal of the defendant was dismissed by the learned Deputy Commissioner by his order dated 30/5/89, passed in RMA case number 19 of 87/88. In order to challenge the legality of the said orders of the Revenue Court, the defendants filed a suit bearing title suit number 24 of 89, in which they sought the relief for declaration that the said orders of the Revenue Court are illegal and without jurisdiction. The plaintiff, along with his father, appeared in the said suit through their advocate Sri D.N. Yadav.
Admitted कैसे आप बोलेंगे? ये admitted थोड़ी होगी. They are asserting that the plaintiff, they had appeared before the.
They say that they appeared, Lord.
When you say that it is an admitted fact.
No, when we say, Lord, specifically कि 84 में
admitted fact नहीं बोल सकते हैं, sir. It is not an admitted fact. It cannot be said to be an admitted
Lord,
fact.
इसमें जब हम लोग का एक प्लेंट का हुजूर जो फैक्ट है, that has to be
जब ये बोल रहे हैं कि 89 के सूट में आप अपियर हुए हैं, तो ये कैसे आप बोलिएगा कि 86 में डेथ हो गया, एडमिटेड फैक्ट है? How will you say this?
He doesn't deny that 84 में डेथ हुआ नहीं हुआ था. He has to say, Lord.
आपका वन लाइन से सेंटेंस से नहीं प्लेन पढ़ा जाता है, सर. The pleadings are to be read not like a statute. It has to be read as a whole, isn't it?
ऐसे प्लेंट में जो अबरमेंट आता है उसे
ठीक, सुन लिए
मिलॉट
आगे
मिलॉट
बढ़ते हैं।
we can only मिलॉट submit for your lordship's consideration कि specific denial नहीं है कि
you see,
84 में
that is not the point. Point of law is section 63 का बार होगा।
main
बस वो
question
main क्या? That is the only question.
that is the only
So you don't travel beyond that.
नहीं ठीक है एकदम बहुत सही
बताइए।
and both the courts did not consider no finding as regards Milord section 63 no consideration which was the main issue in this title suit
No, they have considered section 63. The trial court
63
has
को
considered.
नहीं 63 को लेकर खाली यही कहा कि we cannot go into that question because earlier a competent civil court has decided this is the finding right they did not go into section 63 दोनों ही court they said we can't go in that question section 63 यही finding है ये finding का हम पैरा बता दें क्या
बताइए।
my words
Page number 10. Regarding the
10.
argument made on section 63
Trial-
of
trial
SPT
court.
Act. Trial.
जी हाँ वो लोग यही कह रहा है कि ऑलरेडी कॉम्पिटेंट सिविल कोर्ट का
पढ़िए,
डिसीजन
पढ़िए,
है एंड वी आर नॉट सिटिंग इन अपील
That's right.
यही फाइंडिंग दैट वी आर नॉट सिटिंग इन अपील एज अगेंस्ट द कॉम्पिटेंट सिविल कोर्ट्स डिक्री
ठीक है, पढ़िए।
वही पेज 10 में पैराग्राफ से है
पढ़िए, regarding
Regarding
argument. पढ़िए।
regarding argument made on section 63 of the SPT Act. On plain reading of section 63 of the said act, it appears that there is bar of jurisdiction of the civil courts against the order of revenue courts. Now this is not, but there are exceptions also. That if any order passed by SDO or DC is void and beyond jurisdiction, then suit can be entertained against those orders by the civil court. In this particular case, it is not main subject matter, rather on the same main subject of 63 SPT Act, judgment has already been passed in title suit number 2489 and this court is not hearing an appeal of the said suit. So now this issue is concentrated to the point that whether title suit 2489 in which decree and judgment has been passed was behind the back of the defendants of fraudulent or not. And whether redressal against that particular decree and judgment has been properly sought on. On going through whole above discussed matter, if the decree has been passed by any court, then it will be presumed that it has been passed by following the procedure of law, and if there is any contrary to this presumption, then it has to be proved by this plaintiff by comparing of signature on wakalatnama, show cause petition, information petition, and examination of advocates D.N. Yadav. But in the present case, plaintiff has not come with proof that defendants of title suit 2489 were not present or not contested the injunction matter as per Evidence Act section 101 to 106 and 114. Plaintiff is bound to prove these facts. Rather, from the order sheet of the title suit number 2489, Exhibit 1, it appears that the defendants of title suit number had actively participated for 2 or 3 years. Thereafter, they absented themselves. The plea of plaintiff that father and uncle of defendant of title suit 2489 already died in 84-86 could not be substantiated by any evidence. Rather, petition for information of death of defendant Lakhi Maldar has been filed by the defendant in proceeding of title suit number so and so, which date of death has been shown as 15/1/94. So in this way, your Lordship sees that both the courts, they refrained themselves, my lord, from considering section 63 on the plea, my lord, that a competent civil court has already decided. And unless you prove fraud, they will not go into the decree, validity or otherwise of the decree. This is both the courts, my lord. This is how they treat, their treatment of section 63. That we are not going into that question. And then para 9, my lord, res judicata, which is misconceived. Because this issue of 63 was not an issue framed there in the earlier suit. So res judicata ka principle yahi hai, your lordship knows, lord. Of course.
In the earlier suit, they had raised a point that it was not within their jurisdiction, in as much as they were the descendants of the recorded tenant and they were paying rent.
Huh?
And they were paying rent to the state. That was the plea in the earlier suit.
My lord.
So SPT is applicable on all land, even in cases of inheritance. It is applicable.
Yes, yes.
Even in cases of
inheritance करके भी जो property है, अगर वो illegal occupation में आ गई,
illegal occupation की बात ही नहीं है ना. अगर कोई inheritance से property claim करता है, तो भी SPT का section 42 में eviction हो जाता है.
नहीं, inheritance
नहीं होता है ना.
नहीं
ना होगा. Section 42 will not be applicable.
नहीं होगा.
Therefore, in the suit they have pleaded that they are the descendants of the recorded tenant and they were paying rent to the state.
नहीं गलत है.
गलत है, लेकिन ऐसा नहीं. और ये जो आप जजमेंट साइट
नहीं डीसी और एसडीओ का ऑर्डर देखा जाएगा. वो लोग अपना वैरी कर रहा है, बहुत सा कभी कुछ बोल रहा है, कभी कुछ. नॉट कंसिस्टेंट.
आप ये जो जजमेंट साइट कर रहे हैं इसको पढ़िए. अभी जो सेकंड अपील का जजमेंट साइट किया. पैरा 28 पढ़िए.
Para 28.
Yes.
As has been reiterated by the Honorable High Court in the case of Tarni Marandi and others versus Lakshmi Mahato and others, Section 63 of the SPT Act prohibits any suit inter alia to avoid any order of the Deputy Commissioner. And in this case, the order of the Deputy Commissioner is for eviction of the plaintiff from the suit land passed in Rayati Miscellaneous Appeal number 51 of 2001, it is needless to mention here that there is a provision for revision against the order passed by the Deputy Commissioner in RMA number 51 of 2001-2. But in the absence of any exceptions where suit can be filed despite section 63 of the SPT Act, like the Deputy Commissioner was without jurisdiction, as contended by the Learned Counsel for the respondents, this court has no hesitation in holding that both the courts below have committed grave illegality by ignoring the provisions of
So
section
this
60.
particular judgment also says that if there is a plea that the order was without jurisdiction,
Minor.
then the suit will be maintainable.
Minor.
That
No.
was the tenor of the earlier suit.
तो विदाउट जुरिस्डिक्शन लेकिन है नहीं एसडीओ वाला और वो
बट पुराने सूट में यही बोला गया था जिसमें आपने WS नहीं फाइल की.
जी जी
तो ये कहना कि उसमें नहीं हो सकता था, दिस इज नॉट करेक्ट. सेक्शन 63 का बार उस सूट में नहीं लगता. Because that was the specific plea of the plaintiff, that they were the descendants of the recorded tenant, and therefore this order could not have been passed against them.
you know this
And wo,
this-
एक second, just a moment. The deputy commissioner का order जो है,
एसडीओ का ऑर्डर देखा जाना
SDO का order और appellate order दिखाइए. DC का order.
जी हाँ एसडीओ
DC का order दिखाइए.
जी जी एसडीओ क्या है खरीदा वाली बात बोलता है ये। और अर्लियर जजमेंट माय लॉर्ड आई एम जस्ट पॉइंटिंग आउट माय लॉर्ड अर्लियर जो जजमेंट इम्प्यून किए हम लोग 24 ऑफ 89 में वो 73 का सेल डीड एक दिखा रहा है एंसेस्ट्रल कहाँ से होगा वही जजमेंट देखा जाए वो 24 ऑफ 89 में
आप हमको DC का order दिखाइए.
जी हाँ ये लोग कभी कुछ बोल रहा है कभी कुछ बोल रहा है जी हाँ ऑर्डर शीट मिल गया डीसी वाला हुजूर के सामने है क्या
एक और टाइटल सूट था 77 का, उसका क्या हुआ?
So that was dismissed in default, our non-appearance.
Or whose non-appearance?
We
You
were
also
to play-
filed a suit in connection with the same property.
74,
आपने भी
77
तो सूट फाइल किया।
हम ही लोग फाइल किए।
हाँ, वो उस समय बाढ़ नहीं था सेक्शन 63 से।
बाढ़ तो है ही। उसके बाद ही फिर हम लोग एसडीओ के यहाँ वहाँ डिसमिस फॉर डिफॉल्ट हुआ टाइटल सूट।
In your entire plaint, you have said that it was fraudulently obtained, but it was not your case that because the judgment which has been passed, they have asserted that the orders could not have been passed because they are the descendants of the recorded tenant, or they are claiming through the recorded tenant.
डिसेंडेंट्स करके वो जजमेंट नहीं आया।
Through the recorded tenant, maybe through sale deed,
नहीं सेल डील बोल रहा है।
whatever, but through the recorded tenant, right? Do you want to say that section 42 is applicable
Yes,
even when the property is sold by the recorded tenant?
yes, because under the SPT Act, my lord, it can't even transferable lands which are transferable. Now here in this case, this has come, my lord. SDO's permission is, DC's permission is required for selling that. So that becomes wholly ab initio void and violative of the provisions of section 20, my lord, of the SPT Act.
Where is the order of the SDO?
My lord.
Rather, the DC says that if you want to claim the property, you should have made a plea of adverse possession. DC is saying that. Can DC declare adverse possession? Can DC declare adverse possession?
Can't declare, but the decisions are my lord of the Honorable High Court and Supreme Court that if 12 years continuous possession prior to 1949, my lord 1/11/49 को SPT Act फोर्स में आया। SPT Act आने के पहले अगर 12 साल कंटिन्यूअस ये सेटल्ड लॉ है, इस पर फुल बेंच वगैरह सब है कि 1/11/49 के पहले कंटिन्यूअस पोजीशन अगर है इलीगल भी तो एडवर्स पोजीशन टाइटल हो जाएगा। बट 49 के बाद से आप अगर पोजीशन में 12 साल का दिखा के एडवर्स पोजीशन नहीं होगा तो ऐसी स्थिति में डीसी कैन इविक्ट my lord if it is not proved that adverse possession 12 years possession continuous prior to 1949. DC can evict my lord because that becomes illegal occupation under section 42 of the SPT Act.
They claimed possession since 1935-36.
They are claiming 35-36 उस हिसाब से 49 के पहले वो लोग क्लेम कर रहा है कि तभी से हम लोग हैं, लेकिन उसके लिए कहीं कुछ प्रूफ वगैरह कुछ नहीं दे पाया डीसी के
वो
यहाँ।
अलग बात है ना, डीसी के यहाँ की नहीं बात कर रहे हैं, सूट की बात कर रहे हैं।
हाँ ठीक है,
हम लोग सूट की बात
सूट
कर
भी और एसडीओ के यहाँ भी उन लोगों का वही प्ली था 35-36 but without any
प्रूव नहीं कर पाए, then the DC said that you could have claimed this property
no
by way of adverse
therefore
possession.
therefore illegal possession,
The
illegal
DC himself
occupation.
says that you can claim this property by way of adverse possession, but no such proof has been given.
My lords. So therefore, the DC was within jurisdiction to exercise its power and evict my lord. Since adverse possession prior to 49 could not be proved, so it can't be said that the order passed by the SDO or DC for evicting my lord them is wholly illegal and without jurisdiction. Of course, subject to my lord's consideration, my lord, but this is the settled law. Section 42 may kindly be read, my lord, of the SPT Act. एसडीओ के ऑर्डर में आया है कि कभी ये कुछ प्ले ले रहे हैं, कभी कुछ प्ले ले रहे हैं वहाँ.
और कुछ बोलना है?
That's all, my lord. Both the courts, my lord, did not consider section 63 and no finding on section 63. No summon was issued. वो अगर कहिएगा तो हम दिखा देंगे ऑर्डर शीट से. हम लोग
वो
एग्जिबिट
अलग
किए.
बात. देखिए, जुडिस्डिक्शन का पॉइंट अलग है, फ्रॉड का पॉइंट अलग है. फ्रॉड पर कोई इशू नहीं बना है, इसीलिए फ्रॉड पर हम कोई एडजुडिकेशन नहीं करेंगे.
हाँ, मिलॉर्ड.
ओनली 63 में एडजुडिकेशन.
बस 63. मिलॉर्ड. We bow to my lords, my lord,
देखिए, ऐसे नंबर 346
and
of
always feel
2017.
enlightened, my lord.
This appeal has been heard Mr. Rajiva Sharma, learned senior advocate, appearing on behalf of the appellant, along with अपना नाम दे दीजिए please. This appeal has been filed against the judgment dated 27/4/2017 and decree dated 4/5/2017, passed by learned Principal Judge District Judge Sahibganj, entitled Appeal number 15 of 2014. Thereby the appeal has been dismissed. The trial court judgment is dated 5/6/2014 and decree dated 16/6/2014, passed by Senior Civil Judge -1 Sahibganj, entitled suit number 3 of 2006. And the suit was dismissed on contest. The learned counsel for the appellant has submitted that though both the courts have though there is a judgment of confirmation, but the appeal has been admitted on following substantial question of law. Order dated 25/2/2020. एक लास्ट सवाल, ये अबेटमेंट के बारे में आपको क्या बोलना है? द अपील हैज बीन अबेटेड अगेंस्ट रेस्पोंडेंट नंबर 3. इसके बारे में आपको क्या बोलना है? तो ये ट्रंकेटेड ऑर्डर कैसे हो? During the course of argument, it has also been pointed out to the learned counsel for the appellant that the appeal stood abated against respondent number 3 by the order dated 16/2/2023, to which the learned counsel for the appellant has submitted that he has nothing to say. The learned counsel for the appellant has submitted that one title suit number 24 of 1989 was filed by the defendants seeking a declaration that the order passed by the revenue authorities in RE case number 9 of 85-86 and revenue miscellaneous appeal number 19 of 87-88 is illegal, void and inoperative and not binding on the plaintiff, and a decree for permanent injunction be passed against the defendants of the said title suit, restraining them from dispossessing the plaintiff of the said title suit over the property. The learned counsel submits that the defendants in the said title suit was Kalu Mahaldar, Balram Mahaldar and Jagdish Mahaldar.
लकी भी था, ऑर्डर शीट हम देखें एंटायर, वो लकी का वो लोग डेथ फिर दिखाया और दिखा के डिलीट किया है. सो लकी मालदार और तब कालू.
He has also submitted that Lakhi Mahaldar was also a party in the title suit who was deleted on account of his death.
during the course of
the said title suit. The learned counsel submits that the suit was set ex parte and it was decreed, and a decree was passed for permanent injunction against the defendants in the suit from dispossessing the plaintiffs of the suit the learned counsel submits that thereby in the title suit number 24 of 1989, the order passed in RE case number 9 of 85-86 and revenue miscellaneous appeal number 19 of 87-86 were made inoperative against the present plaintiffs, who are the appellants before this court. The learned counsel has further submitted that in view of bar under section 63 of Santhal Pargana Tenancy Act,
tenancy supplementary
Provisions Act, exactly लिखिए दीजिए, Santhal Pargana Tenancy within bracket Supplementary Provisions Act 1949, the order of the revenue courts in the matter of eviction passed under section 42 of the aforesaid act could not be subject matter of suit. The learned counsel submits that there was a clear bar under the statute and the suit which was filed, being title suit number 24 of 1989, itself was not maintainable, and the judgment and decree passed therein is not binding on the present plaintiffs. The learned counsel submits that the learned counsel has relied upon the judgment passed by this court in Second appeal number 190 of 2019 decided on December 19th, 2024, wherein similar issue has been decided. He has submitted that one of the issues which was, one of the substantial question of law which was framed was, inverted comma, Roman 2, internal page 10 of that judgment, whether both the courts below committed a grave illegality by ignoring section 63 of Santhal Pargana Tenancy within bracket supplementary provision bracket close Act 1949 by ignoring the order of eviction passed by SDO and Deputy Commissioner in RE case number 16 of 1975-76 and RMA case number 51 of 2001-02 respectively, question mark, inverted comma close. He submits that the said issue has been ultimately decided in favor of the appellant and consequently the judgments passed by both the trial court as well as the appellate court has been set aside. The learned counsel has submitted that one more substantial question of law was framed with regard to point of adverse possession, and the appellate court in the said case found that the plaintiff failed to prove his case that he had perfected his title by way of adverse possession.
appellate court deputy commissioner
इसमें पुराना ये second appeal. The learned counsel has referred to the order passed by the deputy commissioner in हाँ
RMA
in
19
RMA नहीं in miscellaneous appeal number 19 of 87-88 and has submitted that before the deputy commissioner also the private respondents were claiming adverse possession but no material were produced before the deputy commissioner and the order of the deputy commissioner became final, which could not have been subject matter of consideration in the earlier title suit of 1989. He submits that the plea of bar under section 63 has been considered by the learned trial court at internal page 10 of the trial court's judgment. But the trial court held that a judgment was already passed in title suit number 24 of 89 and the court was not hearing any appeal against the said suit. The trial court also observed that there is a provision of setting aside ex parte order by way of filing miscellaneous case within time. but neither such petition was filed nor any appeal was filed against a decree passed in the year 1995 in title suit number 24 of 1989, and after 11 years the suit was filed, and the trial court also recorded that the suit itself was barred by limitation. The learned counsel submits that once it is found that the suit was barred by provision of law, the same is void, illegal,
Ab initio.
void ab initio and illegal, and therefore the point of
And without jurisdiction.
and without jurisdiction, and therefore there was no occasion to hold the plaint, the suit being barred by limitation. He has submitted that so far as the appellate court is concerned, the appellate court also did not consider this aspect of the matter properly. And dismiss the appeal. The learned counsel for the appellant has also placed the entire judgment and decree which was passed by the learned court in title suit number 24 of 1989. And upon perusal of the same, it reveals that it was stated by the plaintiffs of the said case that the revenue courts failed to appreciate that permission of section 42 of SPT Act can only be attracted in case of non-transferable land, but in no circumstances on the suit land which are transferable in nature by seeking permission of the SDO ये लास्ट लाइन पढ़िए इंटरनल पेज 2 besides it may have also failed to appreciate that the plaintiffs here long perfected their right, title and possession over the suit land by their continuous peaceful possession much prior to the death of the recorded tenant in the year 1935-36. हम पूरा पढ़ दिए हैं और करेक्टली पढ़े हैं, ठीक है? जस्ट टाइप करेंगे तो ध्यान देंगे कोटेशन में.
Judgment is with me now.
हाँ पढ़िए.
कहाँ पर रुजू?
इंटरनल पेज 2.
Page 3.
इंटरनल पेज 2 पढ़िए.
2 मिला.
हाँ नीचे से 1 2 9
नीचे से
10 नीचे से 9 लाइन्स.
1 2
1 2 3 4 5 6 7 lines. Sorry, 7 lines. It has been further stated.
It has been further stated that the revenue court have failed to appreciate that provisions of section 42 of SPT Act can only be attracted in case of non-transferable land, but in no circumstances on the suit land which are transferable in nature by seeking permission of the SDO. Besides it, they have also failed to appreciate that the plaintiffs have long perfected their right, title and possession over the suit land by their continuous peaceful possession much prior to the death of recorded tenant in the year 1935-36.
It was a case of the plaintiff.
This was the case of,
Yes.
and they admit कि permission with permission of the SDO, जो यहाँ पर कहीं कुछ नहीं है. They could not file before the DC SDO.
That's all.
They could not.
That's all. The learned counsel for the appellant has submitted that the suit was that the title suit number 24 of 1989 was barred by section 63, and therefore the suit which was filed seeking a declaration that the ex parte decree passed in title suit number 24 of 1989 is void, illegal, inoperative, without jurisdiction, and against the provision of law was fit to be decreed in favor of the present appellants. And he submits that the two questions of law which have been framed are fit to be answered in favor of the appellants. That's all. Arguments concluded. एक सौरभ आपके पास है ना लिखने के लिए? हाँ? किसके पास काम नहीं? भेज दीजिएगा लिखाने के लिए. Monday for judgment. Post on Monday for judgment. ऊपर लिख दीजिएगा. In spite of service of notice, nobody has entered appearance on behalf of the respondents. State भी था party. State has not also appeared. सभी ठीक है.
Lord, we stand and enlighten
No,
minds.
everybody is enlightened after reading a brief.
After?
After reading a brief. Everybody is. Even we are enlightened.
My lords, without.
दो 15 के लिए वो 2 15 के लिए.
For admission item 5, first appeal 156 of 2024.
Yes, your case. First appeal 156. I have a query. Mr. Rahul, I just want you to respond to this. Is this appeal maintainable under section 96?
Your Ladyship, this appeal, actually I have to seek instructions and file a appropriate reply. They have filed an IA also. This may
You have
have
filed
to,
an IA?
Yes, I have to take a return of this appeal.
We have taken the
Filing
objection
with
regarding the
appropriate
maintainability.
process. This should have been
You
a
have कहाँ
commercial.
है? आइए दिखाइए.
This should have been a commercial appeal.
Commercial
This should have
appeal
been a
before
commercial
whom?
appeal, and yes, secondly, it should have been filed before the senior commercial court, which is the appellate division in the.
There is a slight twist in this. The district judge has got the pecuniary jurisdiction of 25 lakhs.
No, district judge's pecuniary jurisdiction is 1 crore plus.
1 crore plus
No,
unlimited.
that is the original jurisdiction.
Yes. And in appeal,
In appeal, he can hear
I
order
take
from civil judge, senior division,
only up to 25.
Up to 1 crore. There's a notification you receive. We have
Yeah,
an
where is your IA? IA क्यों नहीं लगा है इसमें? लेके आइए आइए. लेके आइए.
इन्होंने जो
जरा
नोटिफिकेशन
रुकिए
लगाया है
थोड़ा.
तो उसी फिर एनीवेज एज ऑन डेट
कब आपने फाइल किया है?
This is the notification.
आपका आइए कॉपी. भाई यहाँ चेक नहीं करते हैं क्या? बहुत सारा केस मेरे पास लगा है क्या? कम से कम ऊपर के 10 केस तो चेक करना चाहिए. What is this?
district judge's jurisdiction ladyship with regard to 25 lakhs is with respect to non-commercial court matters.
I do not. You see, we will not
I
decide.
would
Just
I
a
have to check all
moment.
that and
Just a moment. We will not decide where will you go. We will only decide that this is not meeting.
I'll file an application for return
Yes.
under section 107 subsection 2
yes.
CPC
Yes.
read with order 7 rule 10.
Yes.
So there I'll have to spell out where it will go.
You do whatever. We permit you to return because this is not the only case.
Oh, acha.
You see, it's a matter of serious concern. This is not the only case.
So now a third thing has cropped up from the question of your ladyship as to whether district judge would be competent to hear the appeal because his jurisdiction is only confined to 25 lakhs.
25.
I think, but this is unsubstantiated, I think he has got the power to hear appeals with regard to all commercial suits which are below 1 crore.
देखिए भैया बात तो हमको यही समझ आती है लेकिन I do not have the notifications. I am inquiring from the office. I am inquiring from the district judiciary also. You also respond
We
because
will
you are aware.
Yes.
Yes, Mr. Rahul, what is happening over there? Is any appeal being filed before the district commercial court?
There are separate notifications with regard to the commercial. There are separate. It would not be covered by the notification which was there with regard to Bengal.
25 lakhs.
Bihar, yes, yes.
Okay, so
Would
that
not
is a
have-
separate thing
Yeah, it's
altogether.
separate
There
notification
can
of the
be
High
a
Court
non-money suit or non-commercial suit which has value more than 1 crore or more than 25 lakhs or whatever.
If it is decided by the commercial court, then obviously it would be guided by the
Commercial
Commercial
notice,
court.
Saying the same
notification
thing which
issued
you
under the
mentioned
commercial court.
yes, yes.
It will not be guided by the general notification
No.
issued with regard to the pecuniary
It
jurisdiction.
would not.
The district judge over there, the commercial division over there, has the appellate jurisdiction also.
Yes, yes. And therefore
Yes,
there
very
are
much.
And
several-
therefore,
Since
our concern is, once there is an appeal which has been filed before the appellate commercial division of the district judiciary, will the matter never come to the High Court? Yes? Under which provision of law the case will come to the High Court? Civil division will be barred. That is not permissible. Only will be 227.
Civil division is barred against interim section 8.
There is no concept of second appeal. Then under such circumstances, the civil division will be barred.
Civil division is barred only against interim.
And what about general civil division? Will that provision apply?
There is no reason why it shouldn't because section 16 says.
That is for the
Please,
learned
please,
advocates.
Please let me come.
Yes.
Section 16 says that CPC will apply with amendments to the extent amendments suggested in schedule to the commercial court side.
That's right.
The remaining all provisions will continue to apply.
The civil division will go to the commercial appellate division.
That is because an order passed by an honorable single judge of this honorable court saying that all civil divisions which are coming before the High Court should principally be placed before the division bench which is hearing the commercial appeals in order
There is
to
an
honor
order?
the spirit. Yes, then that pursuant to that order, the matter was referred to the division bench for consideration. That order was never challenged.
Okay.
So with regard to other aspects,
What
whether
happened
civil-
in that civil
So
division?
then the Honorable Chief Justice, the then Honorable Justice Sanjay Mishra, His Lordship was pleased to exercise his powers as Chief Justice in the administrative side
Okay.
and has prescribed in the Constitution of Benches in which you will find
Okay.
the Division Bench number 1
Okay.
has been assigned with power to hear the all orders passed by the commercial courts.
Okay. So by any means, this appeal is not meeting.
Yes, your leadership is not. I will have, therefore, at an outset I said I will file an appropriate response cum application. Even without I got to know that your leadership had expressed concern on that day, and therefore I was prepared to come with this response. But in the meanwhile, their IA has also come, rightly so. In their IA, they have stopped at only raising an objection that it is not maintainable. Rightly, they have not suggested what will be the remedy that I'll have to resolve.
You place this notification, please.
That is there, my lord. Annexure 1.
ये उनको दीजिए. Please read it. साथ साथ पढ़ेंगे.
In exercise of exercise of power conferred by Section 6 of the Commercial Codes, Commercial Appellate Division of High Courts Amendment Act 2018, the State Government of Jharkhand, in consultation with the High Court of Jharkhand, Ranchi, superseding the previously issued notification 2016 of the department.
It will go
Is
before
there-
the district judge.
Yes.
It's simple. इसमें तो अब कुछ करना ही नहीं है.
ऊपर इसलिए हम रिटर्न के लिए on my oral prayer, if your ladyship is granting, that's a different thing, but I think I should make an application.
अब देरी मत करिए ना.
नहीं दे रही.
अब तो हो गया कानून. क्योंकि this is not the only case. We have to take care of these matters.
Yes, therefore,
एक केस नहीं है. Even in fact, when I was sitting in the division bench, I was just wondering that why commercial matters are not coming before the division bench, because the pendency is very low. Pendency before the commercial bench of this court is very, very low. Only a few cases are there. So I was just wondering कि क्या बात है, झारखंड का ट्रेड एंड कॉमर्स खत्म हो गया क्या? बिकॉज जहाँ ट्रेड एंड कॉमर्स होगा वहाँ लिटिगेशन होगा. तो वहाँ पर जब जाएगा मैटर, यहाँ पे फर्स्ट अपील में एंटरटेन हो रहा है.
यहाँ तो आने में टाइम लगेगा हुजूर.
No, no.
पुराना जो चल रहा है.
Just a moment.
पुराना तो
Here, first appeals are being entertained.
first appeals as against orders
Under
passed by
section 96.
non-commercial courts are entertained.
No. First appeal against the orders passed by the commercial court. तो यहाँ का मैटर तो हमको वहाँ भेजना पड़ेगा, तब ना उसको ठीक चैनल में डालेंगे. Otherwise, my order will become without
So,
jurisdiction.
but for this notification, even otherwise my appeal would not have been entertained here. My appeal would have been required to be converted into commercial appeal, and it would go before the commercial
आप
appeal.
इसको appropriate petition next week file कर दीजिए, right? And then
उसके एक week बाद रखिए next week.
okay, लिखिए FA number 156 of 2024. लिखिए, ये लीजिए. The learned counsel for the appellant, नहीं, an interlocutory application being IA number 736 of 2025 has been filed by the respondent, questioning the maintainability of the present appeal. He submits that the impugned judgment has been passed by commercial court constituted under the provisions of commercial court, commercial appellate division. नहीं, ये एक्ट का क्या नाम है पूरा?
का नाम है the Commercial Courts Act 2015.
The Commercial Courts Act 2015, and has referred to the notification issued by the state government contained in Annexure 1 to submit that a commercial court has been constituted of civil judge within bracket senior division in each district as commercial court to deal with matters of commercial disputes which are of value not less than rupees 3 lakhs and up to rupees 1 crore, and one commercial court of district judge in each district to act as commercial court to exercise original jurisdiction in respect of commercial dispute where value of the suit exceeds 1 crore. He has also submitted that as per the notification, the district judge of each district as commercial appellate court has been designated to exercise appellate jurisdiction and dispose of appeals arising out of judgments and orders passed by commercial court below the level of district judge. he has submitted that in order to entertain an appeal by the commercial court at the district level, comprising of district judge, there is no pecuniary jurisdiction prescribed, and therefore all the appeals arising out of judgments of commercial court of civil judge senior division would lie before the commercial appellate court at the headed by the district judge. Mr. Amit said the first appeal is not maintainable. The learned counsel for the appellant prays for time till 31st of January to file an appropriate petition. Post this case on 5th of February in the supplementary cause list.
Time may be granted till Monday.
Okay? By 4th. ठीक है, by 4th तक आप फाइल कर दीजिए 5th को, and then I am going to fix other matters on the same day.
Because my concern is, and you already shift the language would be prosecution of commercial appellate division. The district judge before whom I will be filing is the commercial appellate division.
Appellate jurisdiction and dispose of appeal arising out of judgments
Sorry,
and orders
commercial
passed by a
appellate-
commercial court.
appellate courts.
Commercial appellate
Capital.
Appellate
So my
courts.
concern is to the return is facilitated so that I can get the court fees also.
You will get
Otherwise-
everything.
Yes. That's why.
You will get everything. When it is not maintainable, you will get everything. The
Right,
court
right.
fees you will get, and then you will have your limitation aspect also will be taken care of. This एक चीज और लिखी है. He has also submitted that the office has not pointed out such a defect with regard to maintainability of the appeal.
In fact, in all the districts, eventually, pursuant to this provision, everywhere that district judge number 3 has been assigned. No, I'm just informing.
They are
All
entertaining. So they are not entertaining any appeals more than 25 lakhs.
Yeah. With regard to commercial courts, they are.
Yes.
With regard to non-commercial matters, they won't.
That's right. But for commercial courts, they should.
I haven't heard that in any matter they have refused to hear appeal because it is more than 25 lakhs. I'll find out now that that issue has arisen. I'll find out the betterment of all concerned. Much obliged.
From Delhi list for hearing item 50, second appeal 152 of 2017.
वो भी लेके आएंगे. वो जो ऑर्डर है एडमिनिस्ट्रेटिव साइड वाला कोई ऑर्डर अगर पब्लिश हुआ हो सिविल डिवीजन
नहीं, वो तो जुडिशियल साइड में था.
वो
उसके बाद हो गया कि ऑल मैटर. अभी आप
Order-
कॉन्स्टिट्यूशन अगर देखेंगे,
ऑर्डर दीजिए जो जुडिशियल साइड में था.
अगर वो ऑर्डर फिर उसका यूज खत्म हो गया हम लोगों के लिए.
Use तो है ना हम लोगों के
क्योंकि
लिए.
हाँ, यस यस, जुडिशियल साइड.
हाँ, जुडिशियल साइड में उसका यूज है, इसीलिए देना जरूरी है. Who is for the appellant? Who is for the appellant? Nobody is appearing for the respondent. वो जो circular है ना उसमें पूरा quote कर देना because that will be useful for other cases also. An extra one है आई का. Where is the appellant? उनका नाम फ्लैश करिए नहीं तो आज DFD कर देंगे इसके से. चलिए. If they are not interested, why should we bother about it? It's last time fine होके ही हुआ था. चलिए.
Item 16, second appeal 159 of 2017.
This is mine, Your Lordship.
Yes.
I'll concede, but I'll not concede in camera. Clients to watch every proceeding.
I know.
It was admitted on.
It can never be lost sight of that every counsel is first the officer of the court,
Yes.
and at least in second appeal.
But when it is broadcasted, otherwise I'd ask my juniors to ask.
That's
So
no, but when it is broadcasted, you have a duty. But at the same time, no duty can be better exhibited than the duty towards law. So your first duty is towards law, and if you mislead the court, your credibility goes. So therefore, law is most important, and we'll take care of whatever it is.
the clients do watch the proceedings.
Yes, they have a right to watch. They have a right to watch. Therefore, every order is going to be a reasoned order. Even in cases where there is no substantial question of law, I have made up my mind that it should be a reasoned order. As to why the court thinks that there is no substantial question,
Yes, yes.
merely because there are concurrent findings, then I have to say that there is no perversity or whatever, and how the courts have come to that finding. I think in a second appellate stage, person needs that much of, so that
Absolutely.
in case he wants to go to the Supreme Court, then he can at least point out that this was the fact, this was
many
the,
a times, Your Lordship, I do say that for many of the litigants, they are so poor that High Court is the last resort for them.
we will take care of it. We don't need to worry about it. Let us see what is it all
Yes.
about.
Your Lordship, the appellant herein was the original plaintiff. He filed a suit, suit dismissed, then appeal also dismissed.
Okay.
The question of law, substantial question of law was framed on by the order number 12 dated 8/12/2022.
Yeah.
The two substantial questions of law were whether the learned courts below were right in dismissing the suit on the ground of limitation, and whether the learned lower court, lower trial court could have dismissed the suit on the ground that the co-sharers were not impleted and therefore the suit was not maintainable due to non-joinder of necessary parties. So, I'll only read out
The findings.
yes.
This was relating to issue number.
Your Lordship may take up the appellate court's judgment, entire thing is there, because the trial court judgment is in Hindi, and then ultimately it has been affirmed by the appellate court. Your Lordship may see that.
What are the points for determination that has been for?
It had not separately formed any
But same
for
issues have been
consideration, but it
considered.
had discussed issue-wise, and it gave the same thing.
This has been in
But
relation
it was, yes, it was discussed.
to issue number 5, and then in relation to issue number 3. law of limitation and adverse possession.
Yes,
So we are only concerned with limitation.
yes. Only limitation and what would be the effect of non-joinder of other co-sharers?
That's right. It's a partition suit.
No, it was a suit where I had claimed, Your Lordship may only allow me to read out the plaint and WS which was filed,
Yes.
which is there reflected in the appellate court's judgment.
Okay, let us see.
That's your first one.
Acha, go ahead. Yes, please.
First page itself of the appellate court judgment.
Yes.
The title appeal has been preferred by plaintiff appellant. Again, the judgment dated so and so, passed in so and so, whereby he has dismissed the plaintiff appellant's title suit number 21 of 2005. The plaintiff appellants filed a title suit number 21 of 2005 for a declaration of their right title interest over the land covered under RS Khata number 457, plot number 2202, measuring an area of 0.24 acres, known as Thakur Badi, and RS Khata number 850, plot number 2202/5977, measuring an area of 0.23 acres, village Kundu, district Ranchi, which is fully described in schedule of the claim, hereinafter referred to as the suit property, and they have alone right to manage, control and perform all the religious rituals of the temple standing over the suit property, known as Mahadevji and Mahavirji private temple belonging to the plaintiff, and also a decree for permanent injunction restraining the defendant from causing any obstruction, disturbance in managing the plaintiff's along with the cost of the suit.
So primarily they are seeking this declaration of their title
Yes,
and also right to Shivayat
yes,
to some extent.
yes, yes. And Your Lordship would also observe
The property stands
that-
in the name of?
on in the name of ancestors of all the ancestors and
Of
of the plaintiffs.
the plaintiff.
But all the descendants of the original persons who were in whose name the record of rights stood, they were not included. Some of them were included, and therefore this was also a question whether the court could have decreed the suit
In
in
absence
absence of the other co-sharers.
Certainly not.
So, therefore, Your Lordship would find the first page itself, last two lines, hereinafter referred, they alone have the right to manage, control.
So they want
So this was,
exclusive reliance
yes, so,
without making
yes,
them party
yes, it was there,
and extinguish their right.
it was there. And
Where is the finding?
defendant number 3 and 4, Your Lordship would find, 1 and 2 were the outsiders. I have a very strong case against 1. There's no doubt because they are outsiders. But as regards 3 and 4, the difficulty is there only. Because they are the other persons who are descendants of the common ancestor.
3 and 4 descendants of common ancestor. And what about those who were not made party? This genealogical table is
There are other persons, and in para 3 I may be allowed to read that would other
Yes.
persons have been mentioned.
is para number 3.
Yes, of the appellate court.
Yes.
The case of the plaintiff in short is that the suit property besides other plot recorded in RS record of right in the name of Triveni Bhagat, Kashi Bhagat and Muni Bhagat, sons of Ram Sarup Bhagat, 3 shares with equal right, Ram Niyadi Bhagat, son of Ram Bhajan Bhagat, 3 shares, Ram Sundar Bhagat, Vaishnath Bhagat and Rajkumar Bhagat, sons of Ram Lakhan Bhagat, 3 shares with equal right, Mahadev Bhagat, son of Harbans Prasad Bhagat, Bhagwat Prasad Bhagat, son of Mahavir Prasad Bhagat, 2 shares with equal right, Sarju Prasad and Bhuneshwar Prasad, son of Sitaram Bhagat, 1 share with equal right. Here Your Lordship would stop, and Your Lordship may compare that with the genealogy which has been mentioned in the first page itself.
Yes.
We are the plaintiffs are the descendants of Ram Niyadi Bhagat, who was one of the person in whose name their record of right was there. And the other branches, they are the descendants of Sitaram Jaiswal, that is Bhuneshwar Prasad and Sarju Prasad, in whose name there was other, but others were the record of,
Amongst in this genealogy, who are not parties? Bhuvneshwar Prasad, Sarju Prasad, they are not party.
well, no, Bhuneshwar Prasad and Sarju Prasad, their descendants are party,
Okay, their
Because-
descendants, Santosh Kumar Jaiswal and Ashok
Yes,
Kumar
yes,
Jaiswal,
yes,
they are
yes.
party.
Yes.
What about who are not party?
It would be Ram Sundar Bhagat, Bajnath, and all the names before this Sarju Prasad.
Where is the finding?
Para 31, Lord. Please.
Para 31. Yes.
Para 20.
Para 20.
20. Therefore, from the above discussion of the plaintiff documentary evidence, I find that the plaintiff failed to prove that he has got a loan right title interest and got managed control to perform or religious rituals etc. over the suit property, because as per admission and exhibit 1 series, certified copy of
That's
RS record of right
Done.
is
What
established.
about limitation? Limitation was also an issue framed.
It was there, and that issue has been discussed in para 32.
Para 30.
This is erroneous. As regards limitation, he could not have said because there is a direct judgment. But even if this is answered in my favor, I have still difficulty in the first one. But this limitation point has been wrongly discussed, which I can show from another Supreme Court judgment, merely because a property is recorded in a name of a particular person and I file a suit after some time. That
The cause of
would not-
action could be different.
there would only a presumption of correctness, that is all attached to it.
That is not conclusive.
Conclusive, it is not conclusive.
And otherwise also, if there are other defendants, okay, then you
This can actually be adjudicated if all the parties are there.
yes.
Then-
Otherwise, this also could not have been adjudicated.
Yes,
Therefore, we can omit the first answer,
yes.
because in absence of other parties,
Even if that is answered in my favor, this
if the suit is dismissed on account of non-joinder of necessary parties, then under such circumstances, no other issue should be decided,
Absolutely.
isn't it? No issue should be. Suppose it is said to be not maintainable, no, nothing should be decided. If it is barred by limitation,
Because,
nothing
yes,
should be decided. Otherwise, in
yes,
general.
because there would be a complication if it is decided, let us assume in my favor, and it is decided that it was within the period of limitation and subsequent it is dismissed for non-joinder of necessary party, then in the subsequent suit, this finding would have,
Hamper. We do not know
it
what
would
impact
have an
it
effect
will
at
have.
least some. The others can say that I was not a party, but your lordship, there were some parties who were already a party in my suit.
So this issue, this point should be decided in your favor. Which is that judgment which you are referring
Yes.
on the point of limitation?
This is Daya Singh versus Gurdev Singh.
Yeah, please give me that. It is referred to in the point of law also, in order dated 8/12/2020.
Yes, yes. And only one line is important. In para 14 and 15, only one line it says, in Mohammed so and so, this court held that the cause of action for the purpose of Article 58 of the Act accrues only when the right asserted in the suit is infringed or there is at least a clear and unequivocal threat to infringe that right. Therefore, the mere existence of an adverse entry in the revenue record cannot give rise to cause.
Right. Thank you. Yes, what
This
you
I
have
am
to say?
submitting.
Or the learned counsel appearing on behalf of the parties.
Lordship, for non-joinder of party, Lordship, I am referring a judgment. Is 2017 Supreme Court cases, Lordship.
2017 SCC volume number
3,
volume
page
3
702.
702 para number
Para, Lordship, 24.
para 24. What does it say?
It is, Lordship. Para 29, Lordship.
Para
29.
29.
As noted above, one of the issue framed is as to whether the suit is bad for non-joinder of necessary party. The said issue was answered against the plaintiff, and it was held that the suit is bad for non-joinder of Janki Ammal, a necessary party whose name was recorded against Survey so without advertising to the said finding of the trial court and the appellate court. High Court has honorously decreed the suit for, of the plaintiff. And in this case, Lordship, there are so many parties are there, Lordship. They had not been made a party to this.
Second
So
appeal
issue
number 1.
one more submission. With regard to limitation, Your Lordship, he mentions, the learned appellate court mentions that the suit was filed in the year 2005, where the record of right was of the suit property was finally published in the year 19. Thus, the suit filed after so and so of publication of record of right is barred by limitation. This is otherwise also bad in view of the fact that we have not challenged the entries of the record. We were not challenging. So, on both these accounts, he could not have said.
Thank you. SA number 159 of 2017. Per the learned counsels appearing on behalf of the parties, this appeal has been admitted by the order dated 8/12/2022 on the following substantial questions of law. By referring to the first substantial question of law, the learned counsel for the appellant has submitted that though there are concurrent findings recorded by both the courts, but the point of limitation has been wrongly considered. He has referred to issue number 3 and 4 as decided by the learned appellate court and has submitted that the appellate court has found that the suit was filed in the year 2005 and the record of right was finally published in the year 1930 and the suit was filed after 75 years of publication of RS record of right, and consequently the suit was barred by limitation. The learned counsel submits that the entry in record of rights was not subject matter of challenge. He has also submitted that the cause of action for filing the suit was not the entry in record of right. He has relied upon the judgment passed by the Honorable Supreme Court reported in bracket 2010 bracket close 2 SSC 194 and has referred to paragraph 14 and 15 of the said judgment to submit that it has been held that mere existence of an adverse entry in the revenue records cannot give rise to a cause of action. The learned counsel submits that the cause of action is governed by Article 58. The limitation is governed by Article 58. इसमें भी 58 है?
58.
58 लगेगा इसमें. 58 of the Limitation Act, and it has to be, and the cause of action accrues only when the right of the plaintiff is threatened. That's it.
Yes.
The learned counsel For the
And I have mentioned in my plaint that the cause of action arose when the defendant started false claim over the suit property and in pursuant thereof, then the cause of
the
action.
learned counsel submits that the cause of action was disclosed in the plaint. That is when the defendants started questioning the right of the plaintiff, and the cause of action as disclosed in the plaint and the materials placed before the court has not been discussed by dealing the issue of limitation.
Yes.
So far as the other substantial question of law is concerned, the learned counsel has submitted that since the main relief was sought for against the defendant number 1 and 2 who were rank outsiders, therefore non-joinder of other descendants of the common ancestor of plaintiff and defendant number 3 and 4 was not fatal to the litigation. Correct?
Yes.
यही आपका
This is my
submission?
submission. Yes.
यही
Thankfully.
at best यही हो सकता है.
Thankfully.
जो आप नहीं भी बोलेंगे वो भी हम
But
I can see
submission,
the litigation.
That must be reflected in the order. That
The learned counsel appearing on behalf of the respondents has opposed the prayer and has submitted that the plaintiff was claiming exclusive right with respect to the property, and the claim was in exclusion of other co-sharers or the other descendants of the recorded tenant, and therefore non-joinder of party was fatal to the litigation, and the learned courts have rightly decided this issue against the appellant. He has referred to the judgment passed by the Honorable Supreme Court reported in bracket 2017, bracket close 3 SCC 702, para 29, and has submitted that in the said case, the issue of non-joinder of parties was framed and it was answered against the plaintiff, but without adverting to the said finding that of the trial court, the appellate court had decreed the suit in favor of the plaintiff. He submits that rights of other co-sharers are involved, and it is an admitted position from the record that the other descendants of the recorded tenant were not made party. Correct? After hearing the learned counsel appearing on behalf of the parties, this court finds that so far as point number 1 is concerned, the same has been answered by the learned appellate court by paragraph 32, which is quoted as under. This court finds that the learned appellate court has referred to the entry made in the arrest record of right published in the year 1930 and no other material has been considered. Even the cause of action for filing of the suit has not been considered, and the appellate court has simply recorded that the suit was filed after 75 years of publication of arrest record of right. Admittedly, the entry in record of right was not under challenge in the suit proceedings. In view of the judgment passed by the Honorable Supreme Court reported in bracket 2010, bracket close 2 SSC 194, this court finds that the cause of action, that mere existence of an adverse entry in the revenue record cannot give right to any cause of action. This court is also of the view that the cause of action is to be seen in the light of Article 58 of the Limitation Act, and the findings which has been recorded by the learned trial court and upheld by the appellate court by recording that the suit was barred by limitation of 75 years by referring to the entry made in the RS record of right way back in the year 1930 cannot be sustained in the eyes of law. Accordingly, the point number 1 is answered in favor of the appellant and against the respondents. So far as point number 2 is concerned, this court finds that the suit was filed by the plaintiffs seeking a declaration that their right title interest over the land covered under RS Khata number 457, plot number 2202, measuring an area of 0.24 acres known as Thakurbari, and RS Khata number 850, plot number 2202/5977, measuring an area of 0.23 acres, village Bundu, district Ranchi, which was described in the schedule of the plaint. They alone have the right to manage, control and to perform all religious rituals of the temple standing over the suit property known as Mahadev Ji and Mahadev Ji private temple belonging to the plaintiffs, and also a decree of permanent injunction restraining the defendant from causing any obstruction, disturbance in managing the plaintiff, in managing by the plaintiffs along with the cost of the suit. This court finds that out amongst the defendants, defendant number 3 and 4 were admittedly the descendants of the common ancestors. An objection was raised from the side of the defendants that all the descendants of the common ancestors were not made party to the suit, and such issue was taken up by the learned court, and learned court recorded a finding in paragraph 18 that the suit was barred for non-joinder of necessary parties. The findings is recorded in paragraph 18. This court finds that the plaintiff had, as recorded in paragraph 18 of the appellate court judgment, the plaintiff had pleaded in paragraph 3 of the plaint that sooner or later recorded rayats, namely the offsprings of Triveni Bhagat and Kashi Bhagat and Muni Bhagat, Ram Sundar Bhagat, Vaishnath Prasad, Rajkumar Bhagat, Mahadev Bhagat and Bhagwat Prasad Bhagat left the village after disposing of their shares, and their whereabouts was not known to the plaintiff. The appellate court considered that the plaintiffs stated that the shares was disposed of, and admittedly they were not made party in the proceedings. This court finds that the plaintiffs were seeking their exclusive right to manage the property. In view of the findings recorded by the learned appellate court, this court is of the view that right of the other co-sharers would certainly be affected by any decree which might have been passed by the courts, by the courts in favor of the plaintiff, and the courts have rightly held that the suit was bad for non-joinder of necessary parties. Accordingly, this court finds that the the substantial question of law number 2 is fit to be answered, is hereby answered against the appellant and in favor of the respondents. This appeal is accordingly dismissed. Right?
Yes. because the suit has been held to be not maintainable
Yes.
in their absence, therefore.
Since the
That-
suit has been held to be not maintainable, has been held to be barred by non-joinder of
Yes.
necessary parties, the present appeal is hereby dismissed.
Item 17, second appeal 169 of
In
2017.
this case, I am appearing on behalf of the appellate.
Good.
Only not today. That's it.
नॉट टुडे करेंगे हम कहाँ आपको नॉट टुडे कभी मना
हाँ,
कर
but-
सकते हैं
Oh.
थोड़ा फाइल खोलते हैं और देखते हैं
Actually, I am not ready in this case.
वी डोंट से दैट यू शुड बी रेडी हम भी तो नहीं रेडी है ना साथ साथ पढ़े
तो अपील एक साथ करना बहुत मुश्किल लगता है.
हम लोगों का क्या होगा
ये रिवर्सल है.
दिस इज एडमिटेड
Yes.
सब्सटेंशियल क्वेश्चन ऑफ लॉ बताइए
And a substantial question of law, if your lordship may kindly see the order dated 11/9/2018.
यस काइंडली रीड इट
There are two substantial questions of law. Whether the sale of land by Shiv Chand through unregistered sale deed is hit under section 17 of the Registration Act 1908, thus confer on the title to his transferee Ram Prasad and subsequent transfer to the Kasimul when second Sachdev Saw, not being the successor of common ancestor Khedu Saw, he had got no right, title, interest and possession by inheritance to sale and the property of Khedu Saw or his successor oblique plaintiff within the meaning of section 10 read with section 3 of the Hindu Succession Act 1956. Second, whether the Court of Appeal below has illegally reversed the judgment and decree of trial court without meeting the reason assigned by the trial court and acted beyond the scope of Order 41, Rule 31 to Rule 34 of the Code of Civil Procedure Act.
आप लोग हमको एक बात बताइए in a case where the appellate court does not meet the reasons then any other substantial question of law of this nature is it required to be point number 1 है is it required to be answered by the second appellate court or it has to be remanded to the court itself?
It has to be, Lordship, answered by the.
Because if the appellate court has not met with the reasons, then under such circumstances we will not supply the reasons for the first time to sustain the finding or reverse any finding.
If it is the Lordship view, then Lordship may remind you.
बोल तो आपको बोले फाइल खोलते नहीं लेकिन this is subject to the yes Mr. Rahul it has to be remanded मान लीजिए कोई मेरिट में भी क्वेश्चन ऑफ लॉ फ्रेम हो जाता है then how the second appellate court will answer that question for the first time.
So once it is remanded, then there's no question of answering other.
Any certainly there is no question of answering any. अब आप हमको impugned order से दिखाई. Yes.
in cases, generally I'm saying.
Generally, I want to hear generally only.
So there would be cases where the appellate court either only in cases where it is reversing,
Yes.
not in cases where it is supporting.
No,
the
no,
other,
no.
then-
Certainly.
then-
Those are different
Yes.
considerations altogether.
Yes. So if it is affirming, then general discussion, but it must appear that
That's
the
right.
appellate court has applied its mind on
That's
the
right.
facts.
No. For
For
a judgment
reversal-
of affirmation, we will not invoke this kind of a jurisdiction. But in a case where it is a judgment of reversal, you cannot have two parallel reasoning to either to decide
Set
an
aside
issue.
the appellate order and affirm the.
Parallel हो जाएगा ना?
Each and every line is not required to be met.
Certainly, but still, by
it
and
must
large-
appear that he has
By and large.
actually met the reasonings of the trial court,
By and large.
and why it is not affirming the view taken by the.
बताइए कहाँ है आपका appellate court judgment? And where is the discussion of the trial court judgment while reversing the appeal?
Lordship, it is in paragraph. Yes, paragraph 9. Lordship.
Let us see the issues framed by the trial court first.
Issue is page 30, Lordship.
Yes, let us see.
इशू संख्या 1, क्या यह सूट संपोषणीय है? इशू संख्या 2, क्या यह बाद लिमिटेशन स्टॉपल वेबर ऑन एडवर्स पोजीशन के दायरे में है? इशू संख्या 3, क्या यह बाद धारा 34 स्पेसिफिक रिलीफ एक्ट के दायरे के बाहर है? इशू नंबर 4, क्या इस केस की कुछ संयोजन एवं असंयोजन का प्रश्न है? इशू नंबर 5, क्या मजहर साव नावल्द मरा या उसका शिवचंद साव पुत्र था? दिस इशू इज डिसाइडेड,
Yes.
very elaborately decided, because Shivchand Sao is no one of the genealogy of this ancestor of this appellant. क्या शिवचंद साव विधिपूर्ण तरीके से उक्त जमीन को रामप्रसाद साव को बेचा? क्या वादी का हक टाइटल उक्त जमीन पर सही है? क्या प्रतिवादी संख्या 1 उक्त जमीन को विधिपूर्ण तरीके से प्रतिवादी संख्या 2 एवं 3 को हस्तांतरण करने के लिए सक्षम था? इशू संख्या 9, क्या वादी का उचित कॉज ऑफ एक्शन है? क्या वादी अपने द्वारा मांगे गए उपचार के अलावा अन्य उपचार पाने के हकदार हैं? दिस टोटल 10 issue has been framed. Important is issue number 5.
इशू नंबर 5 में क्या है? इशू नंबर 5
एक मिनट, issue number 5 has been discussed.
Para 28 is the finding.
Yes, Lordship. this फाइंडिंग है लॉर्डशिप, पेज 54 में है.
Yes, 53. Internal page 28.
Yes. Yeah.
Read it, please.
वही दूसरी और अतः उक्त जमीन पर प्रतिवादी के द्वारा दावा शुरू से ही अवैध है, क्योंकि विधिवत स्वामित्व अगर शुरू में नहीं हस्तांतरित हुआ तो वह कालांतर में कभी भी विधिपूर्ण नहीं होगा.
So initial transfer was bad.
Bad.
Therefore, all subsequent transfers are
Transfer
bad
has been bad.
with respect to the defendants.
Defendants.
Okay. This finding was
Yes.
upset by the appellate court,
Appellate, which is para 9 Lordship.
para 9.
पैरा 9 में पेज 21 में अगर देखा जाता है, पेज 21 इंटरनल पेज 11, from the transfer of land in favor of appellant is by way of registered sale deed, which is a genuine document. It was incumbent upon that this document should have been cancelled by the court below. This is the finding of the appellate court. By giving this observation, reverse the trial court.
Merely because there is a registered sale deed, the court held that the sale was genuine.
Genuine.
There could be a registered sale deed, one party is executing, but that does not confer title upon the original owner of the vendor.
Who sold that land?
Title of the vendor, if it is under cloud,
Yes.
that is to be established.
Yes. Here the appellate court has reversed the entire judgment of trial.
The lower appellate court consider the case of both sides. Case of the plaintiff is that Shivchand Saw was not a son of Madhar Saw. That has been challenged in the WS block, and given a fresh general table, my lord, stating that Madhar Sahib had one son, then the Shipchan Sahib, my lord, and the plaintiff had also admitted in his evidence that Madhar Sahib had one son.
I'm not with that. You see, we are here to see the reasoning of the appellate court.
Yes.
And also see as to whether the appellate court, while reversing the decree, has considered the reasoning of the learned trial.
Lower appellate court has considered the plaintiff's case itself, my lord. Plaintiff case is that there is proceeding under section 87 of CNT Act, which is pending, my lord, with regard to entry in record of right of the defendant's, my lord. Pursuant to that entry was on the basis of the sale deed executed by Shiv Chand, my lord, in the year 1936. And in Gujarat proceeding, the name of purchaser Ram Prasad Sahu was entered, my lord. In his name, several rent receipts has been issued by state government, and the register to his name was entered. Thereafter, Ram Prasad Sahu sold the property in the year 1976 to defendant number 1, and in defendant number 1's name also entered in register 2, and on that basis, my lord, in the year 1926, my lord.
अच्छा एक बात बताइए कि merely because suppose a property belongs to Mr. A and Mr. B executes a sale deed in favor of Mr. C, and this document is registered, will the title of Mr. A extinguish by virtue of registration of a sale deed?
No, that registration, registered sale deed
क्या है
not
registered?
declared invalid, my lord.
आप
That-
इनवैलिड इसी जो ओरिजिनल ओनर है उसको इनवैलिड डिक्लेयर करने की जरूरत ही क्या है? इट इज नॉट बाइंडिंग ऑन हिम बिकॉज ही हैज नॉट सोल्ड द प्रॉपर्टी.
The property was, whether it was property, this property was not ancestral property of the plaintiff.
So
The
therefore,
plaintiff-
I just want to know from you, when the learned trial court has recorded a finding that the initial transfer was bad, and therefore all the subsequent transfers was bad,
that finding
then
of-
on the basis of the same sale deed, how the appellate court has recorded a finding that there was a presumption?
No, on the basis of that
One
sale
thing
deed
more,
itself.
lordship, शिवचंद बोल के कोई व्यक्ति नहीं है.
Yeah, that is the controversy.
Controversy.
You see,
Shivchand-
we are not
Shivchand-
concerned. You see, it is. आप एक बात बताइए. Trial court has passed a judgment, decided an issue by considering the materials on record.
Not considered. That appellate court says.
Where does the appellate court say that this material was not considered?
Yes.
This finding of the trial court is erroneous. Show me. That the finding of the trial court is erroneous on this point.
I'm reading the appellate court judgment, para 7, starting from para 7.
7 से क्यों? Para 9 से finding शुरू हो रहा है, 7 में कहाँ है?
ठीक है.
पढ़ी?
Actual aspect has come from para 7.
अच्छा आपको जहाँ समझ में.
It was argued on behalf of the appellant that in this case, the findings recorded by court below are against weight of evidence on record. The court below also failed to formulate issue regarding the most important document, the sale deed, which was prayed to be cancelled by the plaintiff, being the sale deed dated 3/7/2006. Without cancelling the same, it is not possible to ignore on ground as arranged by court below. Since initial transfer itself was illegal, therefore subsequent transfer shall also be illegal. Moreover, the most important document which was requested to be produced by way of additional evidence, being arrest Hatyar to Khata number 36, lot number 964 relating to suit, was suppressed by plaintiff. That could be best document for just determination of controversy in the matter. Unfortunately, the document could not be filed by appellant during trial, despite having been rejected their plea on same on the record by way of additional evidence at appellate stage. even can be taken in consideration, which is conclusive proof of right title and possession of respondent, and that could also be examined and taken into account before pronouncing judgment if felt relevant and important. Apart from it bringing on record factual matrix, it was further submitted that suit was also inherited by Ram Prasad Saw from Mohan Saw. After his death, it was purchased much earlier in the year 1936, though unregistered sale deed for consideration of Rs 13 only. Consequently, it was sold in the year 1976 in favor of Qasimul Hasan, who was in
Position to what?
possession, got mutated in the government record. He further sold the property in question in favor of Om Prakash Prasad and Ram Sevak Prasad in the year 2006. Their names were also mutated. To Fahmi Saw, who was a recorded tenant, who died issueless, then property inherited by Madhar Saw and Chattu Saw, and Chattu Saw became the owner of the property. Then all the sons, Damari Saw, Hari Saw, and Koleswar Saw, and present plaintiff, Balu Prasad, others have alleged in a family partition as affected in the year 1940. So far, the finding recorded by the court below that since the purchase made by unregistered sale deed and consequent transfer registered could not be invalidated, and the region assigned by worthless initial sale deed have valuation less than 100 rupees, therefore it was not obligation to get registered under Registration Act. The court below failed to consider this very aspect and passed erroneous judgment and order even without cancelling the registered sale deed. The decision of issue number 5, 6 and 7, 8, which have been wrongly decided conjointly taken to record finding arrived by the court below, do not disclose in those favor issue is being decided that was obligatory on the part of the court below, and the approach of the court below in this regard is also erroneous. On the other hand, it was argued on behalf of the respondent that the court below had elaborately taken into consideration the documentary and oral evidence and rightly came to the conclusive finding that initial transfer in favor of defendant respondent was not legal. Therefore, subsequent transfer of sale deed is also bad. Qasimul Hasan could have no right title in any aspect. The genealogy as suggested by respondent is not correct and rather submitted by them in plaint. Plaint is correct one. In fact, there was family partition amongst Dambi Saw, Hari Saw and Koleswar Saw in the year 1940. For which Yaddas was prepared in the year 1940. Thereafter, Koleswar Saw was put in possession. Legal heirs of Dambi Saw and Hari Saw were rightly not included party in the suit. Khatiyan was prepared in the name of Koleswar Saw, Ram Lakhan Saw, Ram Chandra Saw, Sarju Saw. The possession of defendant number 1 was also recorded in the remark column.
Was also falsely recorded.
Possession of defendant was also falsely recorded. This was case of the plaintiff. In the remark column for getting struck out for which suit under Section 87 CNP Act was filed. Ram Prasad Saw was not at all entitled as legal heirs. He had no right to transfer the plot. Moreover, the transfer was hit by Bill 4 of the CNP Act as it was unregistered. This is contention of the plaintiff. Therefore, subsequent made by Qasimul Hasan as the defendant is not sustainable. In fact, respondent plaintiff here having a right title over the suitland since beginning. Provision of Hindu Succession Act specifies that the heirs of first class in succession will oust successor of second class if recorded in any manner. In support to the contention case law 1954 JBCJ, and those provisions of Hindu succession 1950 regarding heirs of class 1 was relied upon to justify the submissions. But with regard to application of Hindu Succession Act, that is not applicable in the present case because admittedly the recorded tenant died much before coming into force of Hindu Succession Act.
आप उसका finding पढ़िए.
After having heard to determine the actual controversy in this appeal, this court found important preliminary issue to this effect whether finding recorded by court below without having cancelled the sale deed in question was justified in holding that since initial transfer was bad, subsequent transfer could not be upheld, rather this shall be illegal in this context from imperative study of oral as well as documentary evidence brought on record and the finding recorded by court below. It is noticed that those witnesses examined by plaintiff are not consistent to the case as set forth during examination by having brought ambiguous, uncertain answer to questions put to them, also failed to narrate even boundary of land in dispute. To example witness Ram Jatan Lohar, who filed his affidavit on being cross-examined, it is stand enough to note he even do not know for what purpose case was being registered, for which he has produced a witness. Moreover, as per his own admission, there is no land belonging to him adjacent to the superfluity who has got possession and demand in his favor. He do not know. This kind of testimony deserves to be outrightly rejected. Moreover, most important is the plaintiff himself, Balo A.S. Vasudev, who had rejected to support his own case without any ambiguity, having filed this affidavit in consonance to the plaintiff's affirmance, but in cross-examination he had also very inconsistent and he also found to be not competent witness. In this matter, it is admitted to the contesting respondent that the revenue records the name of defendants was duly incorporated for getting corrected revenue record. In this regard, action under Section 87 CNT Act was also filed before competent court without having taken into court it is decided. It was not proper to have approached.
You just tell us. The appellate court says that without getting the sale deed cancelled, there was no occasion for the learned trial court to pass the judgment.
Yes.
Correct?
Yes.
There was no prayer for cancellation also. That was not the relief prayer.
रजिस्टर डॉक्यूमेंट ट्रांसफर करने का कोई उनका
तो प्रेयर ही नहीं था.
डेट नहीं था इसका.
तो ऐसा क्यों बोलते हैं? आप हमको ये बताइए, ये the findings which have been recorded by the learned trial court have not been considered. No, what?
The trial court has not considered.
Since there was no
evidence.
prayer to set aside the sale deed, right?
Yes.
Of the year 2006,
Yes.
the trial court could not have decreed it.
Yes.
Now, why the appellate court is saying all this?
The appellate court has elaborately discussed the entire consideration of the trial court mirror, saying that the important evidence who was relied upon in the, is not
अब आप समझना ही नहीं
consistent.
चाहते तो अभी ऑर्डर से ही समझाएंगे, क्या ही बोलेंगे.
The appellate court says, my lord, that evidence of plaintiff is not supporting his claim, lord, and according to plaintiff himself, there is on the basis of a sale deed executed by Suchan.
The appellate court says that the trial court has completely misunderstood the case.
Entries in the record of right, lord.
The appellate court says that the trial court has completely misunderstood the case, right?
My lord.
There are two parties. There is a plaint and written statement.
Yes.
Issues are framed after hearing the parties,
Yes.
and the evidence are to be led on the basis of the issues so framed.
Yes.
And the appellate court says that the trial court has completely misunderstood the case and has decided his own case. Yes.
Appellate court says, Lord, the evidence on the record, Lord, of the side of the plaintiff, Lord, is not consistent, Lord. Even in the case of the plaintiff, that Suchan is the Madhar has that issueless, and so Suchan is no son of Madhar. But in the evidence, Lord, he accepted that the son of Madhar died. That not means that he died issueless. When died, when Tufani died, when Madhar died, had not stated. So unless and until, Lord, not but and the more fact is that not all the authority from 1950 Milord has accepted the Sada sale deed Milord on the basis of that Sada sale deed executed by Srichand Milord, all the revenue or authority accepted and relied upon and entered the name of subsequent purchaser. Rent receipt was gathered. That has never been challenged. And a detailed case of the plaintiff is that his ancestors have never challenged that, and his ancestors' name never entered in the revenue record below.
This is not.
That type of the evidence below that have been ignored by trial court.
कहाँ लिखे हैं? The trial court has ignored this evidence. The finding of the trial court is bad. Where is that mentioned in
Finding of
the?
the trial court is
Lordship, if you are
that
आप
trial
पढ़िए
court
इसका
trial
आप
court
para
has not
10
properly considered.
para 10 para 10 para 10 para 10
Paratin of
the appellate court judgment.
this is an order.
Yes, no, just above para 10. This court having gone through the
This
impugned judgment.
court having gone through the impugned judgment.
पढ़िए
Page 13. Page 13.
page 13.
Internal page 13. This court having gone through the impugned judgment. हाँ पढ़िए. ये तो है.
अच्छा last year. Thus, court having gone through the impugned judgment arrived at a definite conclusion that trial court was misdirected from the legal controversy, committed grave error in approving the registered sale deed without having cancelled the sale, which was not justified in holding the suit to be decreed in favor of the plaintiff. Accordingly, the judgment that finding recorded by court below are hereby reversed to the extent that indicated above the suit filed by the plaintiff before the court below stand dismissed. Consumer unclean judgment and be passed by the court below hereby.
So where is the occasion of the appellate court to come to such a finding? When the trial court has held that the initial transfer made in favor of the defendant was illegal.
The initial transfer, but
अतः उक्त जमीन पर प्रतिवादियों द्वारा दावा शुरू से ही अवैध है, क्योंकि विधिक स्वामित्व अगर शुरू में ही हस्तांतरण हुआ तो वह कालांतर में भी कभी विधि पूर्ण नहीं हो सकती.
that finding Lord is without any evidence. The evidence
कहाँ बोले हैं appellate court कि
Appellate
this
court
finding
से-
is without any evidence.
say by the
आपके बोलने से नहीं होगा ना. Appellate court has to
court
say
says
that this
trial
finding is
court
without
has
any.
not considered evidence properly, Lord. His evidence is not consistent with the plaintiff. That has said, Lord.
Has the appellate court said that the vendor of the defendants had title? This finding has been reversed by the appellate court. This finding of at page number 28, has it been reversed? Read this finding at page number 28 of the trial court judgment.
Trial court judgment. Oh,
ट्रायल कोर्ट जजमेंट का जो फाइंडिंग है, क्या appellate कोर्ट में आपको कौन सी भाषा में बोले? बांग्ला में भी बोल सकते
नहीं,
हैं, हिंदी में बोले. ट्रायल कोर्ट का जजमेंट का फाइंडिंग है पेज नंबर 28 में. हैज दैट फाइंडिंग बीन रिवर्स्ड बाय द लर्नेड appellate कोर्ट? पढ़िए ट्रायल कोर्ट का
या
फाइंडिंग.
दूसरी में बंडा पर्चा में पुलेश्वर सौदा
नहीं, अतः उक्त जमीन पर.
आता second paragraph. अतः उक्त जमीन पर
अतः उक्त जमीन पर प्रतिवादियों के द्वारा दावा शुरू से ही अवैध है, क्योंकि विधिवत स्वामित्व अगर शुरू से नहीं हस्तांतरण हुआ तो वह कालांतर में भी कभी विधिपूर्ण नहीं हुआ, क्योंकि प्रथम बिक्री अवैध था.
यस, इस फाइंडिंग को रिवर्स किए हैं.
Entire finding have been reversed.
दिस फाइंडिंग का रिवर्सल दिखाइए, हम इनका केस डिसमिस कर दें.
इस फाइंडिंग जो हुआ है 12 इशू
appellate कोर्ट सेल डीड का सैंटिटी में चले गए. तो इसीलिए तो the reasons given by the learned trial court to decree the suit has not been met by the appellate court. Appellate court has अपने हिसाब से एक तो केस बना.
1936 का सेल डीड है, उस सेल डीड जो है उस पर कभी ये चैलेंज नहीं किया, इनका ना था इनके फादर प्लेंटिफ का फादर चैलेंज किए.
क्यों चैलेंज?
That is not our case.
was not in possession. He stated in the
Our
evidence
case is for one
he
decimal
said
land lordship.
His sister never challenged
And that too
That's
plot
a-
number
that's a-
510.
आप हमको ये
अब
नहीं,
2000
just a moment, Mr. Just a
2006
moment. Please hold
जो
on.
है,
Please hold on.
हाँ,
ये जो क्वेश्चन ऑफ सब्सटैंशियल क्वेश्चन ऑफ लॉ बना है रोमन 2, इसके बारे में आपको क्या बोलना है? You read substantial question of law Roman 2 and answer.
Whether
whether the court of appeal below had illegally reversed the judgment and degree of trial court without meeting the reasons assigned by trial court and acted beyond the scope of order of 31. इसमें जो है, इसमें तो कहा है कि इनका फाइंडिंग जो है विदाउट कंसिडरेशन ऑफ द एविडेंस, जो एविडेंस है उसको प्रॉपर्ली कंसीडर नहीं किया है, कंसिस्टेंट एविडेंस नहीं है, ये तो कहा है, उसको रिवर्स कर दिया है. तो कंसीडर तो क्या है,
कहाँ दिखाइए ना कंसिडरेशन.
12(9) से
ये जो आप बोल रहे हैं ना कि वो बोले हैं
12(9) में जो है
ट्रायल कोर्ट के कौन से फाइंडिंग को रिवर्स किया है?
इंटायर फाइंडिंग को,
कहाँ से बोल रहे हैं एंटायर फाइंडिंग को?
12(9) and 10 है जो
only it has been stated only regarding the cell deed.
खाली सेल डीड का कहानी की है और कोई कहानी नहीं.
taken it, the lower appellate court had
Rather, trial court has also given observation that Shivchand is no one.
87, the suit is itself not maintainable. That also were taken considerable. That when the plaintiff had filed a case before DC under section 87, during pendency of that, my lord, he filed this title suit, my lord. So, my lord, and he says that there was partition in the year 1940 between the sons of Chhattusha, in which, my lord, this suit property came in possession of plaintiff's father, my lord. But in spite of that, my lord, the value report says that all name, including the defendant's name, is also entered.
Lordship,
in the
kindly
value
come
report, my
to
lord.
page 51. Page
And that
51.
has been challenged, my lord.
Page 51.
Under section 87,
Internal
my lord.
page 26.
If that
Further
proceeding was pending, my lord, then, my lord, during that pendency, this is title suit is not maintainable. And the evidence.
आप देखिए फर्स्ट अपील नहीं बहस कर रहे हैं, सेकंड अपील बहस कर रहे हैं, जो क्वेश्चन ऑफ लॉ बना है बस उसी पे कन्फाइन करें.
That my submission, my lord, the question of point of law.
Not beyond question of law. We will not hear anything
Yes.
beyond question of law.
My submission, my lord, the first question of law, the Swichand, the sale deed led by Swichand, sale deed land of by Swichand through and registered sale deed hit under section 17 of the Registration Act. But admittedly, the sale deed was of the year 1936 of less than value 100 rupees. That was not required to registration.
That's right.
Secondly, the ancestors of the plaintiff had died much before coming to force of Hindu Succession Act 1956 law. So old Hindu law will applicable, not 1956 Act will apply. Thirdly, Lord, whether the court of appeal below illegally reversed the judgment and degree of the trial court without meeting the reasons assigned by the trial court, acted beyond the scope of 31 and 34 of the Code of Civil Procedure. The trial court has also not decided issue wise.
It has decided issue wise. What do you say?
That is Lordship
Issue
Order
wise,
51.
it has been decided.
Rule 31 to 34 speaks about.
कैसे बोलते हैं issue number 1 to 9, issue number 4, issue number 5. Every issue has been decided.
Yes.
इशू नंबर 5 देखिए. इशू नंबर 3, इशू नंबर 4 सब एक एक करके डिसाइड किए. फाइव सिक्स सेवन एट एक साथ लिखा.
5, 6, 7, 8 एक साथ लिए, एक साथ.
तो वही तो issue
हाँ, एक साथ. तो उसमें हुआ कि first question was that whether Shivchan was a son of mother or not. He executed said deed. Shivchan saw executed said deed in the year 1936, and that has been acted upon by revenue authority and recognized that said deed, my lord. And thereafter, on that basis, my lord, several registered sale deed has been executed by subsequent purchaser, my lord. That have not challenged within the time of limitation at that time, my lord. And when in 2006, defendant
has the appellate court said that the suit is barred by limitation? No.
yeah, barred by limitation completely.
तो फिर आप limitation का
only
कहाँ
question
निकाल सकते
decided by the appellate court is the registered deed
हैं? Yes.
had not been cancelled.
Yes.
On the basis of that, he has been set aside the
तो concluding
Trial court judgment.
concluding पारा मिल गया है, लेकिन पारा 9 में जो है सो सब चीज का कंसीडरेशन हुआ है. That has not been prejudiced. Everything has been considered पारा 9. When the existence of Shivchan has been accepted,
वो judgment
as-
letter को, वो judgment क्या नंबर है उसका? ये आपका
Okay.
राकेश जी? आप लोग इस जजमेंट को पढ़ के आइए, सेकेंड हाफ में ऑर्डर लिखा. ठीक है, पढ़. सुप्रीम कोर्ट के जजमेंट्स को साइड करके ये ऑर्डर हुआ है कि सेकेंड फर्स्ट अपील को कैसे डिसाइड करना है. You just take the case number and you come in the second half. आप पढ़ लीजिए उसे. ठीक है. और ऐसा नहीं है कि आपका केस को नॉन सूट कर दिया जाए. In view of the second substantial question of law, the matter will only remanded to the appellate court to consider the issues and the reasoning of the learned track. ऐसा कोई नहीं है कि इनका अपील हम यहाँ से अलाउ कर देंगे. It is not like this.
देख लेते हैं.
आप देख लीजिए. Please have a look.
Password case at 15. Second bill 152 of the 170.
Second appeal, it was admitted on 1/10/2018. The respondent, despite valid series, they had not acted. But
Still
the
we have to decide.
Yes, but the issue, the substantial question has been framed, whether the onus lies upon the person who accepts adoption, as the adoption is not through registered deed, rather factum of adoption has been registered after 13 years. Whether both the court below have heard in law by presuming adoption prima facie valid on the strength of registration is understood. Lord, it is
What is the date of adoption as per the registered deed?
10 to 1970.
10 to 1970.
Yes.
Date of adoption.
Date of adoption. Lord,
When was it registered?
it was registered in 1983, April 1983, exact date not I'm giving.
April 1983.
7/3/1983.
7/4.
3,
1983. Registered.
yes. Lord, the specific case of the
Just a moment. What was the age of the child on the
Yes.
date of adoption?
as per the plaintiff, 20 years.
On the date of adoption?
Yes. And for that, exhibit 1 and exhibit 1 by 1 is the two documents.
Okay, just a moment. You were the plaintiff or the defendant?
Plaintiff.
What was your relief?
Milord, for cancellation of the adoption deed, Milord, it was filed immediately after knowledge in 1883, Milord. The suit was filed. And Milord, a WS has been filed by defendant number 1 and 2, who are the who are claimed, they are, as per the defendant, claimed to be the adopted father and mother. That subsequently that no such adoption has been taken. They have taken the thumb impression on the basis of Bhugat Bandha deed, that is a mortgage deed in Santhal Pargana, and they have got this adoption deed. In the WS they have given. They have what they have done, the defendant, they have filed a joint WS, Milord, showing the WS on behalf of 1 and 2, but immediately after knowledge of the fact by 1 and 2, they came before the court and they have filed a separate WS denying the entire factum of adoption.
So it was an admitted fact that there was no adoption.
Yes, as per them. As per us also, it is known there is no adoption.
So who was the contesting defendant?
Contesting defendant, there are 1 to 5. The natural father, mother, the adopted, so-called adopted son, who is now only alive, that is different. And
The father and mother
yes,
of the adopted son, the natural father and
yes,
mother, they supported the adoption.
yes, they have supported. They have supported that there was adoption. They have in the WS. Subsequently, all the 4 persons died before their evidence. They have died.
So they adopted they
They have
accepted
given.
the adoption.
They have supported that they have given in adoption to 1 and 2. The 1 and 2 they have filed in WS, Milord. That is on.
To whom? Defendant number 1 and 2.
Yes.
So
Defendant
they
number.
they gave the child in adoption to defendant number 1 and 2.
Yes. 1 and 2 they have filed a
What was the cause? Why did you file the suit for the?
Because I am the next heirs to inherit the property, because 1 and 2 died issueless. I am the nephew.
Okay. The property would come to you.
To us.
Okay. If the adoption is invalid.
Invalid.
सुनेंगे second half.
एक चीज और इसमें करना चाह रहे हैं, because they have not appeared. If you lot subsequently if they challenge this order, Milord, in Supreme Court that we have not appeared, there is no alternative. ये नहीं हुआ है. Paper publication नहीं हुआ है.
क्यों जरूरत है पेपर पब्लिश?
If अगर it is then.
Sole respondent appeared through वकालतनामा.
But their name is not appearing in the.
कहाँ है का वकालतनामा sole respondent का?
Is not appearing in the. Most probably then will.
देखिए.
Is not appearing in
It
the
is
list.
in
Most
the-
probably Mr. Dev was
Just a
appearing then.
moment. In the order sheet, in the note sheet, it is mentioned that the sole respondent has appeared through वकालतनामा.
But name in the list, most probably Milord, then Mr. Dev was appearing at that time, Milord.
अरे ऐसे most probably बोलकर आप
Because
मत-
name is not appearing in the list. List में किसी का नाम नहीं आ रहा है respondent के तरफ.
आपका जो फाइलिंग वो होता है कंप्यूटर में, उससे आपको नहीं पता चलता है कौन
किसका
appear
नाम
हुआ
नहीं
नहीं हुआ.
आ रहा है. नाम
देखिए
नहीं आ
सर.
रहा. Yes. मुझे लगता है उनका नाम डिलीट हो गया.
देखिए
Deleted.
रिकॉर्ड में देखिए ना भाई, कोई वकालतनामा कहीं तो होना चाहिए. ऑन व्हाट बेसिस आर दे सेइंग दैट द सोल रेस्पोंडेंट हैज अपीयर्ड? इसमें चेक करिए, इसमें हो सकता है. ऑफिस से बुला के पूछिए किस बेसिस पे लिखे हैं, पूछते हैं
Yes.
लिखे हैं तो कोई तो बेसिस
कोई
होगा, ऐसे
basis
बिना
होगा,
देखे नहीं
yes.
लिखे होंगे।